My name is Richard.
Endowooza y'abalabirizi ba kkooti gye bawaayo eripooti.
Number 810 of 2020. Uganda versus Lubega Yusuf A1, Waswa Hussein A2, Salim Zamiru A3, Nakandi Hajara A4, Abubakar Cherola A5, Kisalita Mahad A6, Kato Hassan Miro A7, Bukenya Ismail A8, and Bubumo Musa Abbas A9.
Uganda ngewabira abantu bano wammanga Lubega Yusuf number Waswa Hussein number 2, Salim Zamiru number 3, Nakandi Hajara number 4, Cheolwa Abubeka number 5, Kisalita Mahad number 6, Kato Hassan Miro number 7, Bukenya Ismail number 8, ne Bubumo Musa Abbas number 9.
Introduction. The accused persons were each indicted with the offense of kidnap with intent to procure a ransom, controlled section 243(1) and C of the Penal Code Act, Cap 120. And murder contract sections 188 and 189 of the Penal Code Act, Cap 120. On the first count, the prosecution alleges that the accused persons and others still at large on the 7th day of February 2018 at Lunguja in Kampala district, they kidnapped Suzan Magara with intent to procure ransom for the benefit of her liberation from danger of being murdered.
Nti omuwala gavumenti yagamba nti ng'ennaku z'omwezi 7 omwezi ogw'okubiri 18 nti mwe abawabibwa mwawamba omugenzi Suzan Magara era nga mumwagalako ssente ennyingi ze mwali mutwala oluvannyuma ne mumuta.
On the second count, the prosecution alleges that the accused persons and others still at large between the 25th and 27th of February 2018 at Konge in Kampala district with the malice aforethought, they unlawfully caused the death of Suzan Magara.
Nti omusango gw'okubiri gwa kutta kigambibwa nti ng'ennaku z'omwezi 25 na 27 omwezi ogw'okubiri 2018 mu kitundu ky'Ekkonge mwatta omugenzi Suzan Magara obutali bugenderevu.
Upon plea-taking, all the accused persons denied committing the two offenses. Background of this case. 28 at around 8 p.m. Okay. PW1 Muhindo Mugururu Yusuf, a friend of the late Suzan Magara, called her, and as they chatted on phone, he hears her say, "Don't beat me." And a man asked her if she wanted to scream, while another said, "Beat her."
Omujulize yasooka ya bamuyita Muhindo Mugururu yakubira omugenzi Suzan Magara ku ssimu era n'awulira ng'akaaba ng'agamba kitemunkuba naye ng'abalala mugamba nti mukube nti ne yeewunya yali abadde ki oba yali amukuba.
He therefore noticed that there was a scuffle and his call was dropped.
Nti era yakizuula oluvannyuma ku ssimu nti waliwo okubanagana nti era essimu ye oluvannyuma n'evaako.
He then called a friend, a police officer, Jonathan, who called the district police command of Kawente then, and he then called his cousin, Keguko Scovia, who then called Robert Magara, Suzan's uncle.
Yakubira mukwano gwe omulala we Kawempe nti ne bakubira ne omugenzi oba akowa omugenzi Suzan Magara.
On the 8th of February 2018, around midnight, Magara Robert then reported to Old Kampala police station.
Magara Robert yawaaba omusango ku poliisi ya Kampala Mukadde.
That his niece, Suzan Magara,
omwana wa muganda we Suzan Magara,
an accountant with the Gwendero Dairy Farm, had been kidnapped by unknown persons around 9 p.m. while on her way home. Following the report, the police officers and relatives initiated a search for Suzan Magara. Later, her vehicle registration number UAJ 790W was found in Lunguja with the engine still running. No, 790W. 0W. In Lunguja with the engine still running. Lowered and 2 mobile phones belonging to Suzan Magara were left inside. The following day around 9 p.m., unknown individuals began communicating with the Suzan relatives using different Airtel Uganda mobile numbers. And they were demanding a ransom of $1 million United States dollars for her release. Suzan's father negotiated with the kidnappers and agreed on a ransom of $200,000 United States dollars. It was further agreed that Suzan would speak to her parents to confirm her safety, which she did. On 15th and 17th February 2018, the kidnappers made 2 attempts to collect the ransom, but both attempts were aborted due to suspicions that the family had involved the police. On 19th, kidnappers called Suzan's father and instructed him to collect a package from Haas petrol station along Entebbe Road. He went and picked the package, and on arriving home, they opened the package, which contained a video labeled "A Must Watch." The package also contained 2 fingers. The video showed Suzan Magara pleading with her father to pay the ransom without involving security agencies. On the 24th of February 2018, around 10:30 a.m., a ransom of United States dollars 200,000 was delivered by Flavia Magara at Kanaba Ndeje village off Busabala Road in Makindi Municipal District. However, on the 27th, off Entebbe Express Highway near Kitiko Birongo village in Mutungo Parish, Makina Division, in Wakiso district.
naye ng'ennaku z'omwezi 27 omubiri gw'omugenzi Suzan Magara gwasangibwa ku luguudo lw'Entebbe olupya oba express highway mu kitundu ekiyitibwa Kitiko, mu kyalo ekiyitibwa
Kitiko Birongo.
nga we gusuuliddwa.
The body was taken to city mortuary at Mulago for a post-mortem examination,
Omulambo guno gwatwalibwa e Mulago okuba nga gwekebejjebwa,
which revealed septic stamps on her left little and ring fingers, indicating they had been severed.
nti era gwalagibwa nti okwekebejja kwalaga nti yali agibwako engalo bbiri era alina obuvune ku mukono gwe.
To be asphyxia due to manual strangulation.
Okuttibwako omugenzi ono kwali mu bugenderevu olw'okuba nga bali mwagala ssente.
Burden and standard of proof. Let me start by restating the law. The burden of proof lies with the prosecution.
Nti aba gavumenti balina obugugu okuba nga bakakasa kkooti kituufu ekintu kino kyakolebwa.
It's the prosecution's responsibility to prove each element of the offences charged beyond any reasonable doubt, and this burden does not shift to the accused person.
Aba gavumenti balina omugugu okuba nga bakakasa kkooti ddala obutuufu omusango guno ogwazzibwa era gwakolebwa mu abawaabirwa, nti era guno omugugu tekuba nga guvavaako okuyita mu kuwuliriza omusango guno,
except where a specific statutory provision provides otherwise.
ng'oggyeko nti waliwo amateeka bwe galaga nti omuwala gavumenti ayinza okuba nga agibwako omukono guno.
See the case of Wilmington versus DPP,
ng'olaba omusango ogwo ogw'omu
1935 appeal cases on page 462,
gwasalibwa ng'ennaku z'omwaka 1934
and the case of Okethe Okale and others versus Republic, 1965 East Africa at pages 555.
n'ogwo omusango omulala bonna bayogera ku kintu kyekimu.
This case does not involve a shift in the burden of proof to accused to demonstrate their innocence.
Nti musango ogwo balaga nti omugugu teguba ku ba gavumenti, gubeera ku bawabi ba gavumenti okuba nga bakakasa kkooti ddala mwemwaza omusango.
The standard of proof in criminal cases is beyond reasonable doubt.
Nti okukakasa kkooti mu misango gya naggomola kulina kubanga kugenda kukolebwa obutalekaawo omulungufu gwonna.
This does not require absolute certainty, but the evidence must be sufficiently strong that there is no reasonable possibility of the accused's innocence.
Omuwala gavumenti alina okukikola ng'aleeta obujulizi mu kkooti obutalekaamu kamulungu konna nti mu butuufu waliwo akawaatwa akalaga nti abantu bano tebakola musango ogwo.
Decided by Lord Denning in Miller versus Minister of Pensions, 1947, two original reports at page 372, and at pages also 373 and 374.
Era ekyo kyalagibwa mu musango ogwo gwasalibwa emyaka egyo emingi emabega gwayogweddeko ogwa Miller versus Minister of Pension.
It says the degree of beyond reasonable doubt is well settled. It need not reach certainty, but it must carry a high degree of probability.
Nti okubanga bakakasa kkooti n'okuterekamu ku mulungufu gwonna tekiina we kikoma oba tekiina we kitandikira, naye balina okukikola nga tebalekamu omulungufu gwonna.
That proof beyond reasonable doubt does not mean proof beyond a shadow of doubt.
Nti okukakasa kkooti tekitegeeza nti balina okugenda mu maaso n'okukakasa kkooti nga tebalekawo kisikirize kyonna.
For the law would fail to protect the community if it admitted fanciful possibilities to deflect the course of justice.
Nti amateeka gaba gakuuma ebitundu singa waba nga walimu obulungufu obusigaddemu.
Let's move on. Evidence must be evaluated as a whole.
Nti obujulizi obuleetebwa mu kkooti aba gavumenti bulina okwekebejjebwa bonna wamu.
Relating to each element before reaching a conclusion.
nti kooti erina okuba nga eraba obujulizi obwetibwa bwa gavumenti n'obwetibwa abawababirwa nga tenabagenda mu maaso okuwaayo ensala yaayo.
The prosecution's evidence should not be considered in isolation from the evidence presented on behalf of the accused.
Obujulizi bw'omuwaabi wa gavumenti tebulina kuba nga bukakasibwa bwokka nga tebatadde mu nkola obujulizi bwabo abawabirwa bwe baleese.
In Abdul Ngobi versus Uganda Supreme Court Criminal Appeal number 10 of 1991, this is what the Supreme Court stated.
Nti mu musango ogwo ogwa Abdul Ngobi ng'awaabira Uganda, kkooti ez'enkulu ya Uganda yayogera bw'etyo mu 1999.
That evidence of the prosecution should be examined and weighed against the evidence of the defense, so that a final decision is not taken until all the evidence has been considered.
Obujulizi bw'omuwaabi wa gavumenti tebulina kugenda mu maaso okuteekebwa mu nkola nga tebannaba kulaba obujulizi bw'abawaabirwa okusobola okuba nga babugatta oba ne babulaba bombi wamu ne baleka bawa ensalawo yaabo.
That the proper approach is to consider the strengths and weaknesses of each side, weigh the evidence as a whole, apply the burden of proof as always resting upon the prosecution, and decide whether the defense has raised a reasonable doubt.
Ekikulu ekyalibadde kikolebwa kwe kulaba obugumu oba amaanyi agali mu bujulizi obuleeteddwa aba gavumenti n'amaanyi agali mu bujulizi obuleeteddwa mmwe n'obunafu obuli mu bujulizi obwo obw'enjuyi zombi nga tebalaba kutuuka ku nsalawo ya kooti.
If the defense has successfully done so, then the accused must be acquitted.
Nti bwe baba nga abawabirwa baleese obujulizi obumala, then abawabirwa mulina okuba nga.
But if the defense has not raised a doubt that the prosecution case is true and accurate, then the witnesses can be found to have correctly identified the appellants as the persons who was at the scene of the incidents as charged.
Abawabirwa oba abalooya bamwe baba tebaleese bujulizi bulaga nti ddala obujulizi bwa gavumenti bulimu obulungulu oba tebulaga nti ddala kituufu mwazi omusango ogwo, ekyo kitegeeza nti mmwe mulina okuba nga mwejjeerezebwa.
In determining a case, the court has also to bear in mind the duty to evaluate all the evidence on record, both for the prosecution and the defense, and arrive at its own findings as to whether the offenses for which the accused persons were charged have been proved to the required standard.
Nga kkooti egenda mu maaso n'okusalawo omusango era obujulizi obweteddwa obwa gavumenti n'obujulizi obweteddwa mmwe n'egenda mu maaso etunuulira n'ereeta oba n'eggyamu ekinyusi n'eraga ddala kituufu mwazi omusango oba temwabuza.
The prosecution was representation. The prosecution was represented by Nachimbuge Irene, Chief State Attorney, Joseph Chomuhendo, also Chief State Attorney, and Nalwanga Sherifa, also Chief State Attorney, representing the DPP.
Abawala gavumenti babadde bakiikiriddwa bano wammanga nti asooka bonna bawala gavumenti bakulu, Joseph Chomuhendo, owokubiri ye Irene Nachibugwe, n'owokusatu ye Sherifa Nalwanga.
At the beginning, the defense was represented by the following counsel. Counsel signed and up Kenya for A8 Bukenya Ismail and A9 Bugumba Musa Abbas. Then Counsel John Kabagambe Fulbega Yusuf A1 and Zali Musamiru A3.
Kabagambe John yalasikira Fulbega Yusuf ne Sali Musamiru nga mwabirwa asooka n'owokusatu.
Counsel Peter Benjamin Wanda was for Kisalita Muhammad A5 and Chawala Bubakar A6.
Peter Wanda, lawyer, yali achiikirira Kisalita Mahad nga mwabirwa bamukwaga.
Chawala Bubakar.
Nechewolwa Abubakari wokutaano.
No, yes, okay, fine. Counsel Richard Kumbuga was for Wasa Hussein and Nakandi Hajara, as well as Kato Hassan Miro.
Lawyer Kumbuga Richard yali achiikirira Wasa Hussein, Nakandi Hajara, wamu ne Kato Hassan Miro.
However, It was later agreed to harmonize all the representation such that they all hold joint instructions for all the accused persons.
naye oluvannyuma kyateezeganyizibwako oba nekikkiriziganyizibwako nti mwenna wamu mube nga mukiikirirwa balooya babiri oba omu.
The assessors in this case were Rita Padere,
abatulizi ba kooti omu ye Rita Padere,
Magoba Brenda, and Sarah Babire, who all took oath in this case. And they all took oath before the beginning of witnesses. And they are the following: Muhindo Mugururu Yusuf, Kiganira Enoch, Magara Robert, John Fitzgerald Magara, Gerald
Magara,
Immaculate Kabajurisi Magara, Regina Renata Magara, Magara Flora. I think it's enough for me just to read it, hearing them. The names are straightforward. Magara Flora, John Makumbi, Wasa Segawa, Frank Nyakairu, Sergeant Sabire Sudi, Kayondo Lawrence, Moses Biaruhanga, Kiria Musa, ASP Senono Ismail, Police Constable Bwire Crispino Dudinga, Barasha Shamilia, Kanene Enoch, Sergeant Ramwenje Moses, Musumba Dennis, Ichoto Robert, Superintendent Adam Muhangi, Mugabire Asmar, Nabuma Tausi, Luganda Joffrey, Nanyinya Joffrey, Mtege Edwin, Namubiru Irene, Mteza Stephen, Mamul Hassan, Ndaula Kajansi Mukasa, Mohamed Imran, Lule Moses, Kigula John Mutebi, Juliet Naiga, Wandera Desire, Chaningom Pius, Okello Michael Jackson, Mukalas Livingstone, and Dr. Nwamanya Manuel. Then Asimwe Maureen, Kabera Francis, Wandera again Desire testified as a number 44, and Sylvia Chelengat testifying as PW 45. 1. An official from National Identification and Registration Authority who was summoned by court to ascertain the registration details of A7 Kato Hassan Miro. The defense, on the other hand, called 20 witnesses with their relevant documents admitted as exhibits. The defense witnesses included the following: Lubega Yusuf, Waswa Hussein, Salim Usamiro, Nakanda Ajara, Cherwabu Bakar, Kisalita Mahad, Kato Hassan Miro, Bukenya Ismail, Buvumbo Musa Abbas, Mariam Nakalega, the mother to A1, and Nalubega Isha, sister to A1, Nakaiza Sania, mother to Kato and Waswa, Namfuka Aisa, stepmother to Kato and Waswa, Gombe Fasil, husband to Nakandi, A4, Nalumansi, a wife to Chowala Bobakar, Kato Yunus Bukenya, the father to defense witness number 8, that's Ismail Bukenya. Defense witness number 17 is Nansubuga Christine, a wife to Ismail Bukenya. Defense witness Nakandi Marion, sister to defense witness number 9, that is Buembo Musa Bas, and Hadija Nangozi, mother to defense witness number 9, and the last one was Kasalire Edidisa, defense witness number 20. Following evidence was agreed upon by both parties and duly admitted on the court record. But you'll realize there are so many exhibits here. Exhibit number 1, joint communication matrix of Yakub Biensi. Exhibit number 2, communication links between ransom numbers and family members. Exhibit number 3, final joint communication of participants and associates in the Suzan Magara CRB 141/18 case. Exhibit number 4, we have technical analysis report on the kidnap and murder of Suzan Magara. Exhibit number 5, post-mortem report. Exhibit number 6, DNA analysis report under request from Detective AIP Ochowun Selias. Exhibit number 7, forensic report. Exhibit number 8, forensic report, question the document, exhibit number 1. And exhibit number 9, chain of custody log, question document number 2. And also exhibit number 10, sketch plan of the scene of murder. Again, exhibit number 11, photographs of the sketch. Prosecution number 12, crime scene investigation report. 13, photographs of Konge 2 zone. Number 14, homicide secondary crime scene 2 investigations report. Exhibit number 15, homicide secondary crime scene 4 reconstruction reports, Wide Old Kampala. And then Buike photographs, exhibit number 16. We also have Luero homicide secondary crime scene 5 reconstruction and photos. Exhibit number 17, Natete report and photos. Exhibit number 18, scene reconstruction video documentation report. Exhibit number 19, draft sketch plan of Usafi scene, which was drawn. Exhibit number 20, video photographic evidence report on crime scene number 14/5 of 2018. Exhibit number 21, a video photo evidence report on crime scene. Exhibit number 22, land sales agreement between Luganda Geoffrey and Lugolobi Hakim and others. Exhibit number 23, bank statements, statement of accounts of Luganda Geoffrey. Exhibit number 24, sales agreement between Irene Namubiru and accused persons. Exhibit number 25, receipts and driving permit of Lubega Yusuf. Exhibit number 26, photographs of the Carina vehicle UAK 140U. 27, exhibit 27, HS investment UAV 138G agreement for sale of motor vehicle. Exhibit number 28, agreement of sale of motor vehicle UBB 711R Costa Fuso. Exhibit number 29, Usafi Mosque video. Exhibit video report. Exhibit number 31, Buike videos. Exhibit number 32, Luero. Exhibit number 33, car sale agreement. Exhibit number 34, land sale agreement. Exhibit number 35, translated versions of the audio and report in Runyoro. Exhibit number 36, exhibit records. Exhibit number 37, clothes that were worn by the deceased. Exhibit number 38, an exhibit slip. Exhibit number 39, identification parade report and sketch map of the identification parade. Exhibit number 42, number 40, exhibit record 87499. Exhibit number 41, exhibit record 87596. Exhibit number 42, land in Luero, Bulemese block 203, plot 218. Exhibit number 43, land title block 488, plot 2. Exhibit number 44, UBD, motor vehicle UBD 70F. Exhibit number 45, motor vehicle UAQ 470R. Exhibit number 46, motor vehicle UAW 183L. Exhibit number 47, motor vehicle UBB 993L. Exhibit number 48, motor vehicle UAK 140U. Exhibit number 49, motor vehicle UAX 962G. Exhibit number 50, motor vehicle UAV 138G. Exhibit number 51, motor vehicle UAY 683G. Exhibit number 52, motor vehicle UBB 711R. Exhibit number 53, exhibit slip showing pictures of the flash. MTN, police exhibit number 90, call data from MTN. Exhibit number 91 to 107, call data from Airtel. Know your customer, exhibit number 108, and laboratory report. Police exhibit also 109, a court order. Exhibit number 111, police form 17A. Police exhibit number 112, nature of crime. And prosecution exhibit number 113, a court order. The first exhibits which were submitted and admitted in court were two. That is Dr. Dambuma Tausi's statement. The Dr. Tausi's statement. And the second one was a statement of the Soko. Submissions by the prosecution. I said earlier the prosecution called 45 witnesses and relied on a combination of direct and circumstantial evidence. This is their submission, that it is well settled that proof beyond reasonable doubt does not mean proof beyond a shadow of doubt. Case of Miller. The prosecution says that the defense does not contest the first two ingredients of kidnapping with intent to procure ransom. But challenges only the ingredient of participation in respect of both offenses. The prosecution therefore addresses the first ingredient separately and the ingredient of participation in both offenses concurrently. Prosecution submits that Suzan Magara was forcibly abducted against her will on the 7th of February 2018. That PW1 Muhindo Yusuf, the last independent witness to speak with her, testified that during a telephone conversation he heard her scream and plead with unknown persons not to harm her.
Nti omujulizi asooka Muhendo yagamba nti bwe yali ayogera n'omugenzi Suzan Magara ku ssimu yawulira ng'akaaba nga yeegayirira nti tebamutwala nga tamanyi ng'ayogera n'abantu abali tebategeerekeka.
That was followed by dead.
Era yagenda okuwulira abasajja nga bamugamba nti towoggala ng'essubi tenabakubibwako.
This account was immediately reported and consistently maintained. According to the prosecution, PW 37, Detective Inspector Wandera Desire, confirmed that Suzan Magara was intercepted and forcibly removed from her vehicle near her residence in Sendaula zone in Lunguja.
Nti yagamba nti Wandera Desire yagamba nti omugenzi Suzan Magara yawambibwa oba yasalibwako ng'ali ku kutuuka ewuwe Lunguja n'awambibwa n'aggyibwa mu mmotoka ye.
That her Toyota RAV4 UAJ790W was found abandoned a short distance away with the doors open and lights on circumstances wholly inconsistent with voluntary departure.
Emmotoka ye namba oba bagiyita RAV4 Toyota UAJ 790 DW yasangibwa ng'eri awo erekeddwawo ng'amadirisa gali wansi ng'era ekyatokoka.
This was corroborated by PW2 Sergeant Kiganira Enoch and PW3 Magara Robert and PW12 Detective IP Kayondo Lawrence, who attended the scene the following day and recovered 2 phones and a computer cable from the vehicle.
Nteera obujulizi buno obwakwatagana bw'omujulizi obwokubiri n'obwokusatu n'obwokumi n'ababiri abaagenda mu kifo omugenzi Suzan Magara gye yawambibwa olunaku lw'enkeera ne basanga essimu 2 ez'omugenzi Suzan Magara wamu ne layini ya kompyuta nga biri mu mmotoka.
That on 19th February 2018, the kidnappers directed the family to collect a parcel containing 2 severed fingers with a red nail polish.
Nti ng'ennaku z'omwezi 19 omwezi ogwokubiri abaawamba omugenzi Suzan Magara baalagira ab'enganda z'omugenzi Suzan Magara nti bagende babeeko ekitereke kye bafuna era ng'ekitereke kino kyalimu engalo 2 ezaliko oba bayita tutex z'abakyala.
PW14 Kiria Musa, a forensic scientist at the director of government medical laboratory, generated a female DNA profile from the fingers.
Omujulizi ow'okumi Kiria Musa eyava mu kitongole ekyekebejja ebisaayi yakebera engalo zino 2 era n'aleeta ebyava mu kukebererwa.
On 5th March 2018, he compared it with a blood sample from Suzan Magara submitted by PW40 and confirmed a match.
Nti ng'ennaku z'omwezi 5 omwezi omukebera engalo zino byagattibwa oba byakebejjebwa oba byalabibwa wamu n'ebyava mu kukebera omubiri gw'omugenzi Suzan Magara.
The scientific evidence proved that Suzan Magara was alive and under the kidnappers' control when the fingers were amputated.
Nti kyasangibwa nti omugenzi Suzan Magara yali mulamu era ng'ali mu mikono gy'abo abaali bamuwambye ng'engalo ze ziggyibwako.
The prosecution cited the case of Uganda versus Musimami and 2 others, criminal session case number 31 of 2011.
Abawalo gavumenti bawa kkooti omusango ogwa Uganda nga ewaabira Busimaani era nga guli 20 ogwa2011 gwasalibwa.
Where kidnapping was defined as the taking away or transportation of a person against that person's will.
Nti bayogera ku kintu ky'okuwamba omuntu nga kitegeeza nti omuntu oyo awambibwa n'atwalibwa nga tegeesiimidde.
Usually to hold that person in false imprisonment without legal authority.
Nti era kitegeeza nti omuntu oyo akuumibwa mu kifo ng'awambiddwa oba ng'asibiddwa nga ekifo ekyo tekiri mu mateeka.
The prosecution submits that the first ingredient has been proved beyond reasonable doubt.
Era abawo gavumenti bakakasa kkooti nti ekintu kino ky'okuwamba bakikakasa kkooti nga tebaleseemu kulungu.
The prosecution maintains that the second ingredient was proved through the evidence of ransom demands and negotiations and collection attempts.
Ekyokubiri kwali kufuna ssente ezaawamu oba ennyingi.
That PW5 Immaculate Kavajurizi Magara received a call on 8th February 2018 from number 0759 249 058 informing her that Suzan Magara was in their custody.
Nkyera omujulizi ow'okutaano Immaculate Magara yagamba nga ali ku ssimu eyo 07 59 249
058
058 nti n'abagamba nti ssente yali azirina.
Then on 9 February, the same caller demanded $1 million ransom.
Nti era ennaku z'omwezi nga mwezi ogwokubiri eyali avuga omulala yagamba nti baagala miliyoni $1.
The negotiations continued and the amount was later reduced to $200,000.
Mwagenda mu maaso oba bagenda mu maaso n'okubanga bakkaanya nga beegayirira abakomereyo omugenzi Suzan nga bagamba nti ssente tebalina era ne mukka wansi abaali bawoza oba basaba ssente ne bakka
The kidnappers directed the family to multiple collection points.
Era mmwe abaali bawambye omugenzi Suzan Magara baalagirira famire ebifo eby'enjawulo bye bali balina okubasangamu.
Masaka Road on 15th February.
Masaka mu luguudo lw'e Masaka ng'ennaku z'omwezi 5 ogwokubiri.
Matuga on 17th February.
Matuga 17 ogwokubiri.
Kanaba Ndeje on the 24th February. The first two attempts failed because the kidnappers detected security personnel. That on 24th February, $200,000 was successfully delivered at Ndeje. And voice recordings exhibit number 77 captured the kidnappers insisting the money should not be paid in installments or be counterfeit. A video on the same exhibit showed Suzan Magara pleading with her father to meet the demands. PW18 Kanene Enoch, the digital forensic examiner, authenticated the recordings and confirmed the photo. The prosecution also cited the case of Uganda versus Namibia and another criminal session case number 461 of 2017, where the court held that kidnapping requires a specific intent to obtain ransom.
Nti era abagavumenti bawa kooti omusango omulala ogwasalibwawo ng'era mwaliwo okuwamba ogwa Uganda ng'erwabira Namubiru namba 4/12/2017 era nga kugamba nti omuntu awambye alina okuba nga alina ekigendeerwa ky'okufuna essente zonna.
That the organized surveillance of collection points, repeated demands, and successful collection of the $200,000 clearly establishes this specific intent.
Nchera okubanga nga mugenda mu maaso nga mubawa ebitundu ebyokuziteekamu era nga mugenda mu maaso nga abagenda mu maaso abali bawambiso abali bawambye nga bagenda mu maaso nga basaba ssente nga bazisaba buli kaseera kyalaga nti ssente ezo zaali zirina okuweebwayo era neziweebwayo.
The prosecution therefore submits that the executive ingredient has also been proved beyond reasonable doubt.
Era omwa gavumenti ababa gavumenti bakakasiza kooti nti ekintu kino kyakolebwa era ssente zaweebwayo.
The prosecution relies on the doctrine of common intention, submitting that all 9 accused persons acted in concert throughout the kidnapping, the detention, the ransom collections, and murder.
Abala gavumenti beesigamye ku kintu ekiyitibwa okubanga abakola ekintu ekyo bonna baali wamu era nga balina ekigendererwa kyekimu era nga balina ekigendererwa kya kufuna ssente era nga bawambye omuntu era ne bamala.
That the evidence forms a complete chain linking each accused person to the offenses.
Era obujulizi bulaga bulina obati twandiyise akatambu ekigendererwa ekyokuba nga kireeta abawabirwa ku musango ogwo.
On the telecommunication evidence, PW10 Frank Nyakairu traced the deceased's phones immediately after the abduction and prepared a communication matrix, which was exhibited as PX1 number 1, showing that all accused persons were in constant contact with each other and with the anonymous ransom numbers before, during, and after the offense.
Nti omujulizi na 10 ekibwa Frank Nyakairu nti yagenda mu maaso n'afuna essimu z'omugenzi Suzan Magara n'agenda mu maaso ng'agenda mu bitongole byazo n'alaba empuliziganya egenda mu maaso nti era empuliziganya eyo yalaga nti mwenna abawabirwa mwali muli bumu era nga mwali mwogera kuba ku ssimu.
PW18 Cybercrime Analysis Exhibit number 8 placed several accused, that is Yusuf Lubega, A1, Hakim Lugolobi, and Mahad Kisalita, etc., in the same locations as the ransom collection points of Masaja, Matuga, Namasuba at the material times. Pardon? PW 18 cybercrime analysis.
Obujulizi namba 18 nti yaleeta obujulizi nga bulaga nti abawawabi baabo bayogeddeko bwenna mwali mu kifo kyekimu era nga mwogerezeganya nga mugenda
of the prosecution on arrests and conduct that the accused person's conduct during the arrest was inconsistent with their innocence.
Nti era kyalaga nti nga bakwata mmwe abombi bakwata nti kyakiraga nti temera kyemumanyi ku musango guno.
That A5 Cho, for instance, A5 Cho or Abu Bakar obstructed officers attempting to arrest Bukenya Ismail A8.
Nti okugeza nga kyewulwa Abubeka yagezaako okulwanyisa nga bakwata munne
Bukenya A8.
Kenya na uwabi w'omunana.
That A1 Yusuf Lubega fled into Safi Mosque.
Nti era omujulizi asooka Yusuf Lubega yadduka n'agenda mu muzikiti,
triggering a violent confrontation.
era n'agezaako okulwana.
A9 resisted arrest.
Mukumbo Musa Abbas omwami w'omwenda yagezaako okulemesa abamukwata.
A4 hid her vehicle.
Ate Nakandi Hajara yakweka emmotoka ye.
So in George Wilson Simbwa versus Ugandan,
Musango ogwo ogwa George Wilson Simbwa,
criminal case number 371 of 1995, the court
nti omuntu okubulawo okwekweka oba okudduka nga omusango gwakakolebwa kiba kiraga nti omuntu oyo alina kyamanyi ku musango ogwo.
on admissions and scene reconstructions, the prosecution submitted that after arrest, A1, A4, A5, and A8 made some admissions to PW 37 and voluntarily led investigators to multiple scenes.
Nti nga bamaze bakwata nti omuwabirwa asooka Yusufu wamu n'ekyewolwa Abubakar owookutaano mwatwala omujulizi owasatu mu omusanvu gyonna gye mwali mwaziza musango.
They identified the kidnapping vehicle UAK 140U Karina.
Era emmotoka eyatwala omugenzi oba gye mwawambiramu omugenzi yali UAK 14 Karina.
They identified places of detention, that is Natete and Upper Konge.
Era ne mumutwala gye mwatereka omugenzi nga mumuwambye Natete ne Konge.
They also identified ransom collection points.
Era ne mumugamba nti mwafuna ne mumutwala we mwafunira ssente mutwala birejja dola.
They identified the property purchased with ransom money.
Era ne mumutwala ettaka ku bintu bye mwagula nga mukozesa ssente ezo.
And they identified the body disposal site at Kitiko Birongo.
Era ne mumutwala gye mwakasuka omulambo gw'omugenzi Suzan Magara.
These reconstructions were documented by PW 21 Inspector Ichot Robert.
Era bino byonna byakola
Ichot Robert.
Robert.
And PW 22 ASP Muhangi Adam. Through photographs, sketch plans, and a video. PEX 54. That the accused persons demonstrated intimate knowledge of locations and events that only participants could possess.
Nchera mwakozesa amagezi mangi nga mumubuulira wonna mubabuulira wonna we mwagenda era nga kino kiraga nti mwali mulina kintu.
Prosecution holds that PW 21 and PW 22's evidence was corroborated by PW 38 Pius Chaningom, who took custody of the exhibits.
Nchera abagavumenti bagamba nti obujulizi namba 21 ne namba 22 bugenda mu maaso ne bukwatagana n'obw'omujulizi number
38
Pius Chaningom.
and also was corroborated by the evidence of PW 40, Corporal Mukalas Livingstone, who maintained the chain of custody of exhibit number 54. Section 28 and 29 of the Evidence Act, Cap 8, permit proof of facts discovered as a consequence of information received from an accused person. On asset tracing, the prosecution submitted that they traced the ransom money through independent witnesses. Land and motor vehicles were purchased in March and April 2018. Motor vehicles, not just one. 35 acres in Buike, that is which was bought at 140 million. And there was an exhibit PW 25, exhibited by TW25. As well as 1 acre in Duero was also traced. But they also traced other vehicles like an Isuzu Elf, Fuso Rosa, tipper trucks. Now, PW 37 recovered logbooks, sale agreements, and titles linking these assets to the accused persons. He cited the case of Simon Musuke versus Republic, and also the case of Siraju and another versus Uganda. Which say that the conduct after the offense may strengthen an inference of guilt when viewed alongside other proved facts. That this pattern of rapid asset acquisition is submitted as powerful circumstantial evidence of benefit from the ransom. On the offense of murder, that A1 the group decided to kill Suzan Magara because she had been with them too long and she could identify them. That A9 injected her with a ketamine and suffocated her with a polythene bag. This was corroborated by pathologist Dr. Birhanga Moses, who found the cause of death to be asphyxia. The presence of sellotape at Apankonge House, shown in the reconstruction video, further confirmed the deceased's confinement. On the issue of identification, PW7 and PW9 positively identified A5 at the endangered ransom drop sites in broad daylight. A5 Chewa Abubakar, at the Ndege ransom drop site. And they saw him in broad daylight. The identification was tested at the identification parade, exhibit number 39. That in Abdallah Dabulere versus Uganda, the court held that the identification evidence must be tested with great care, but where the quality is good, the quality of identifying is good, as herein above, in broad daylight.
Nti yagamba omusango gwe bagamba nti obujulizi obw'okulaba omuntu ng'ali kunyiririrwa wamu ne banne bulina okukolebwa oba okukwatibwa n'obwegendereza nga bateeka mu nkola ebintu bino ebimu ku byo okuba nti obudde bwali bwa misana.
It was at close range. And they had ample time to identify him. And so a court may safely convict even without corroboration, provided it warns itself of the need for caution. In conclusion, the prosecution submits that the evidence forms a complete and unbroken chain, proving all the three ingredients of the offense beyond reasonable doubt. That forcible abduction with a specific intent to obtain a ransom, and the active participation of all the accused persons through common intention, that the combination of telecommunications data and confessions and scene reconstructions, forensic evidence, asset tracing, and eyewitness identification leaves no doubt that the accused persons kidnapped Suzan Magara for ransom and subsequently murdered her.
Kyogenda mu maaso ebyawetebwa mu kkooti amasimu empuliziganya engeri yamawuliziganyagamu okuwamu omugenzi Suzan Magara okusaba ssente n'okumutereka ne byonna byakolebwa biraga nti tewali kabulungufu busigadde kirala kituufu mwe mwakola ekintu ekyo ate oluvannyuma ne mumutta.
Submissions by the defense.
Okuwaayo oba okwogerako kw'abalooya bamwe.
Save for the crucial element of participation by the accused persons.
Mwagenze mu maaso ne mukkiriza obumuntu bwonna obuli mu musango guno nga muggyeko okwegaana nti siwe mwakola omusango.
The defense respectively submitted that the prosecution has utterly failed to prove beyond reasonable doubt that any of the accused persons participated in the kidnapping with intent to murder or in the subsequent murder of the late Suzan Magara. The defense says that the evidence adduced is weak, inconclusive, uncorroborated on material aspects, and riddled with the contradictions, hearsay, and attribution failures that leave this honorable court with substantial reasonable doubt. That which must be resolved in favor of the accused persons, resulting in the acquittal. According to the defense, the case arises from the tragic abduction of Suzan Magara on the 7th of February along Kabaka and Jagala Road in Mengo, Kampala. A substantial ransom of approximately 700 million was reportedly paid, yet she was not released alive. Her body was recovered on 27 February 2018 in Kigo, Wakiso District. That while the prosecution alleges that Yakub Biensi and Hakim Lugolobi remain at large,
nti wadde nga bagamba nti mwenna mwali wamu era mwakolera wamu nti abantu babiri balina okuba nga bakyakusagusibwa omu ye Yakubu Byensi
and Hakim Lugolobi,
wamu ne Hakim Lugolobi era nga abantu bano bona bakulabikibwako.
That this fact alone demonstrates that the child accused persons are at best alleged peripheral participants whose involvement rests on a fragile web of circumstantial evidence insufficient to sustain convictions on capital charges.
Kiraga nti obujulizi abawala gavumenti bwe baleese tebutegeerekeka era tebulimu kinyuzi okuba nga bugenda mu maaso n'okubasiigisa omusango.
It is the submission of the defense that the cornerstone of the prosecution case is the testimony of PW10 Nyakairu, Frank Nyakairu, an operative attached to Chief Counsel of Military Intelligence, and PW37 Wandera Desire, the investigating officer.
Nti abawa gavumenti bagamba nti obujulizi bwabwe obusinga bwesigamiddwa ku bujulizi bw'omufisa w'amagye Frank Nyakairu wamu n'omulala Wandera Desire nga obujulizi bwasatu mu musango.
The investigating officer.
Era nga yakola okunoonyereza mu musango guno.
That through PW10, the prosecution tendered the so-called final communication matrix derived from an Airtel call data record.
Nti okuyita mu mwabiro ogw'okumi Frank Nyakairu nti abawa gavumenti baleeta ebyava mu mpuliziganya obutongole by'empuliziganya.
That PW10 assigned specific roles to each accused person based on his interpretations of the matrix.
Nti era omujulizi ono yagenda ng'anoonyereza ku buli mwenna okusinziira ku mpuliziganya ze mwakolanga.
And claimed, for instance, that Hassan Miro kidnapped and guarded the deceased.
Era n'agamba nti okugeza nti Hassan Miro omuwawaabirwa ow'omusanvu nti yalinga akuuma omugenzi.
That Hajara Nakandi kept guard as the deceased was allegedly held in her room.
Nti era omulala Hajara Nakandi naye yalinga akuuma omugenzi ng'ali mu buwambe gye mwali kutadde.
That Abubakar Chawaloa collected a ransom.
Nti era Abubakar Chewelwa nti yafuna ssente ezo ez'awamu.
That Mahad Kisalita provided funds for lines and fuel.
Nti ate Mahad Kisalita yawaayo ssente asola amafuta ne ssente ezaali zikola bitundu.
That Salim Muzamiru received and decided on the use of money.
Nti ate Salim Muzamiru yafuna era n'agamba ssente gyezirina okukolebwamu.
That Yusuf Lubaga was involved in surveillance, kidnapping, ransom collection, and body disposal
Nti ate Yusuf Lubega
as the driver.
Yali yenyigira mu kuwamba n'okutwala omugenzi Suzan Magara ng'era yali avuga motoka.
That Yakub Biensi was the co-driver.
Ate Yakubu Byensi yali munne era nga bavuga bonna motoka.
That Abbas Musa Mbuembo acted as the doctor who administered ketamine to kill the deceased, and other accused persons performed various roles.
Nti Lugumbo Musa ye yakuba omugenzi empiso era nti n'abalala nabo bakola ebintu eby'enjawulo.
It is that PW10 further claimed that Yusuf Lubega confessed at midnight.
Nti omuwaabi w'ekumi yagamba nti Yusuf Lubega yagamba yakkiriza ssaawa 6 ogw'ekiro.
So it is the defense assertions that these narratives suffer from incurable defects.
Nti mwe mugamba nti okwogera kuno kwonna tekulina butuufu bwako.
According to them, no witness from the network provider was called to prove that the accused persons were the actual users of the telephone lines at the material times.
Nti mwe mugamba nti tewali mujulizi n'omu yayitibwa okuva mu bitongole ebyo eby'amasimu kugeza nga MTN oba Airtel nti okwakata ddala kituufu mwali bannannyini masimu abo.
And that in Uganda it is a notorious fact that SIM cards are frequently shared. They are borrowed, they are sold, or used by multiple persons.
Amasimu gasobola okuba nga bageeyazikibwa nti ne gakonika oba ne gakozesebwa abantu ab'enjawulo.
They also say that cell tower data is imprecise and cannot establish actual usage of all participation.
nti era mwagamba nti obujulizi obwo bwayitibwa okuba mu bitongole by'empuliziganya bukuntanibwa era tebusobola kubanga buleeta ekituufu.
That the Electronic Transactions Act requires proof of reliability, integrity, and authenticity of electronic data.
Ebyuma ebyakozesebwa bibulwako okubanga biraga obutuufu bwabyo engeri ebikozesebwamu tebisobola kubanga bireeta ekituufu.
And the defense claims that the prosecution failed to meet the standard.
Era mugamba nti abawaga gavumenti balemererwa okubanga bakakasa ekituufu.
They claim also in their defense that PW37's evidence introduced material contradictions and hearsay.
Nti mugamba nti omuwala wa 37 yaleeta ebintu ebitakwatana ate nga ebimu byawulibwa buwulibwa.
And testified that John Magara picked it at Haas petrol station and that the family discovered the contents at home before police collected it there.
Nti omujulizi namba 37 yagamba nti omwami John Magara yafuna ekitereko ekyo n'akitwala ewuwe ne bakisumulula era poliisi yakirola ewuwe nga bamaze okisumulula.
They maintain that this directly contradicts PW10's claim that John Magara delivered the fingers to the police station.
Nti bino bikontana n'obujulizi obwa namba 10 okugamba nti John Magara yatwala ekitereko ku poliisi.
And that PW37 originally mentioned ketamine in the parcel.
Nti era nti omwala 37 yagamba nti obujulizi obwo bwalimu ebiso eyatta obugenzi.
That these discrepancies destroy the chain of custody of this crucial exhibit.
Nti era buno byakwatagana mu bujulizi buno bulaga nti waliwo obutali butuufu.
That while DNA may link the fingers to the deceased, the exhibit proves only that torture occurred during captivity. It does not establish participation by any accused person.
Nti newandibadde nga endaga butonde yava ku mubiri gw'omugenzi eraga nti engalo ezalabibwa zali za mugenzi tekitegeeza nti mwe mwakola ekintu ekyo ky'omugenzi.
That no fingerprints, no DNA or forensic links were recovered tying any of the accused persons to the amputation.
Nti tewali kintu kyonna ekyakolebwa nga okuva mu kasawo ekyali kiraga nti mwennyini mwenyinira okuta omugenzi.
They insist that the bulk of narratives regarding most planning meetings, the role distribution, the surveillance, the kidnapping, execution using toy pistols, masks and a hammer, and the hostage shifts.
Mugamba nti ebintu byonna ebyakozesebwa ebyo
were hearsay.
byali si bituufu biwulibwa buwulibwa.
That PW37 was not present at any of these events.
Nti omujulizi namba 37 teyaliwo mu bintu ebyo byonna byonna.
That PW37 suffered from memory difficulties.
Nti omujulizi namba 37 alina obulwadde bw'omutwe. Memory difficulties is not to say he suffered from a disease of the mind. That PW10 effectively considered that a substantial part of his evidence, including the role assignments, the ketamine allegation, and the midnight confession, was derived from information provided by Yusuf Lubega, without whom he had no other evidence. That this transforms his testimony into a repackaging of contested, retracted statements obtained in highly irregular circumstances, late at night without independent safeguards. That videos shown in the court depicted suspects admitting things they never did. That other prosecution witnesses, according to the defense, compound these weaknesses. That the evidence of PW14 lacked fingerprints evidence. nti obujulizi bw'omujulizi namba 14 bwali bubulako kyewandiise fingerprint.
That PW 15 described a masquerade arresting over 200 people on guesswork with poor separation of adults and children.
Nti omujulizi namba 15 yalaga nti bakwata ne bawamba ate ne batwala abaana abato ne babagata n'abantu abakulu.
They said PW 18 confirmed call data records but provided no specific identifications.
Nti omujulizi namba 18 yaleeta ebikwata ku ssimu empuliziganya y'essimu naye teyaleeta baani abayogera.
That PW 19 offered no identification for any arm injury.
Nti era omujulizi namba 19 teyalaga kintu kyonna oba obujulizi obwali bulaga obufune mu bwobwako.
That PW 20 contradicted himself on the circumstances of arrest.
Nti era omujulizi namba 20 yali akontana n'engeri abantu oba mwe mwakwatibwamu.
PW 21 and 22 gave conflicting evidence on the arrest location of Waswa Hussein in Iguikwe versus Usafi and Ledozira.
Ate abajulizi namba 21 na 22 bawa obujulizi obutakwatana okukwatana okukwata Waswa Hussein.
They failed to prove the ownership of the alleged Konge house. That no landlord, LOC witnesses, land titles or rental agreements were tendered. Yet Bukenya Ismail disowned the house. That was not the one renting that house. That the alleged transactions in Buik were not linked to Kato or Waswa. That PW 27 failed to identify suspects in land purchases. And they claimed that the evidence powerfully reinforces reasonable doubt. Defense asserts that when the prosecuted evidence is subject to rigorous scrutiny, it reveals itself to be fundamentally deficient. Defense asserts that when the prosecution evidence is subjected to rigorous scrutiny, it reveals itself to be fundamentally deficient. That the communication matrix suffers from incurable attribution failures. So the law on circumstantial evidence is settled. And they also cited the case of Bogero Moses versus another, the Supreme Court decision of 1997, and the case of Simon Musoke versus Republic of East African Court of Appeal, by then, where the prosecution case depends wholly, saying that where the prosecution case depends wholly or substantially on circumstantial evidence, then the inculpatory facts must be incompatible with the innocence of the accused and incapable of explanation upon any other hypothesis than that of guilt. That the evidence must point irresistibly to guilt and exclude every reasonable possibility of innocence.
nti obujulizi obwo buba bulina okuba nga buleetebwa nga tebulekaamu kintu kyonna kiraga nti abawabalibwa balina kye batalamu.
And they are saying here that mere association
nti kigambibwa nti okuba nga omuntu yegenda mu maaso n'okwegatta oba
that phone contacts or mosque membership
okuba nga omuntu ayogerezeganya oba n'okuba nga ali wamu n'omuntu
does not establish common intention under section 20 of the Penal Code Act.
Tekiraga nti waliwo ekigendererwa ekyawamu nga kirambikibwa mu kitabo ky'amateeka.
And that since the masterminds, the principal actors in this case, that is Yakub Biensi and Golobi Hakim, are still at large, the two who are still at large. That further underscores that any alleged role of the accused persons is peripheral and unproven.
ekintu kyonna oba byakolebwa oba okugenda mu maaso n'okwenyigira mu nkutta n'okuwamba bikyakontanet.
The defense concluded by saying that prosecution had failed to discharge its constitutional and evidential burden. That participation requires credible, direct, or sufficiently corroborated evidence of actual involvement in the actus reus, not a mere association or investigator-derived narratives.
okugenda mu maaso n'okwenyigira mu kukola omusango kitegeeza nti omuntu yagiyingiramu so si kubanga olina omuntu gw'okolegana naye oba gw'oyogerezeganya naye bye bagamba.
And they conclude by saying, we therefore most humbly pray that this honorable court finds each and every one of the accused persons not guilty on all counts and acquits them accordingly. And should order the immediate release from custody. It's now the role of the court to evaluate this evidence. For the accused to be convicted of kidnapping with intent to procure ransom, the prosecution must prove each of the following essential ingredients beyond reasonable doubt. It must prove unlawful taking of the victim, that the taking away was by use of force, fraud, or coercion, and that was with the intention of gaining a ransom or a reward, and they have to prove that the accused persons participated in the commission of the act. Firstly, so I'm now dealing with unlawful taking of the victim. Firstly, prosecution is required to prove beyond reasonable doubt that the victim was unlawfully taken away. For this ingredient, there must be proof of the victim being removed, which in law is called as portation. And it was removed against her will from one location and taken to another location. So transportation of the individual is an essential element of the crime. And the movement must be more than something slight or inconsequential. A substantial distance from the vicinity where she was found. We find this in the case of Namubiri Fiona and another High Court Criminal Section case number 0461 of 2017. The prosecution relied on the evidence of PW1 Mohindo Gumuguru Yusuf,
Omwala gavumenti beesigama ku bujulizi bw'omujulizi asooka Muhindo Yusuf.
Mugululu Yusuf Muhindo, yeah, yes. Who testified that on the fateful day of 7th of February 2018, 2018, yes. He was busy at Parliament preparing for an official trip to Switzerland. He spoke briefly with Suzan during the day and called her back at around 7:50 p.m. as he was leaving the parliamentary basement. But as he drove towards Chambogo using earphones, Suzan informed him she was also driving home from the gym. It was also his evidence that while at the Kiambogo University West Gate being checked by security, he suddenly heard a scuffle over the phone. It was his evidence that Suzan screamed in Uganda, saying, "Temukuba, don't beat me." He further stated that he heard at least 2 distant male voices. That one asked if she wanted to scream, while another commanded, "Beat her." That Suzan pleaded that she would not scream if they stopped hitting her. Then the call remained active for about 40 seconds to a minute before it was dropped. It was also his evidence that in a state of panic he attempted to call a 999 but received no response. Who advised him that Suzan's suspected location was near Mengo, which fell under Old Kampala Police jurisdiction. So he turned his vehicle and began driving towards the city center, seeking to find a police patrol. It was also his evidence that at Jinja Road Police Station, he met an off-duty officer named Enoch, who contacted a security tracker who confirmed Suzan's phone was active in Lunguja area. He rang his cousin called Keguho Oscovia, who contacted Suzan's family. And their company colleague called Dennis, who then eventually located Suzan's vehicle. It was this vehicle that they found Suzan's RAV4 parked neatly on the side of the road, and upon peeping through the window, they saw women's clothes inside, but Suzan was nowhere to be found. They also relied on the evidence of Sergeant Kiganira, PW2, and a police officer attached to CID headquarters cybercrimes department, who testified that was approached by Muhindo at Jinja Road Police Station. No, at Jinja Road Police Station. And that he told him that his friend Suzan Magara was not picking up her phone after he had a suspicious couple during their last call. He began a formal tracking process for Suzan's phone for Suzan. He contacted someone from MTN called Gladys. Then reached out to Lieutenant Nyakairu at Siamambuya, who provided coordinates for the victims' phones. It was his evidence that tracking data indicated that devices were located in Lunguja area. He also said he joined Muhindo in his car and they drove towards the coordinates in Lunguja. And when they were moving, Muhindo tried to call Susan's phone again. At one point, the call was answered by Dennis Biancha, a family member who had already arrived at the scene. Then Biancha provided directions leading Kiganira and Muhindo to the location where Susan's blue RAV4 had been abandoned. That upon arrival, they found about 10 to 12 people identified he identified himself with his warrant card and contacted the OCCID and OC operations of Old Kampala Police to report the situation. And a patrol car soon arrived to secure the scene. PW2 testified that the victim's car was parked on the left side of the road, facing the direction of her home. It was his testimony he observed the 2 mobile phones inside the car. He confirmed their presence by calling the numbers and hearing them ring within the locked vehicle. The prosecution also relied on the evidence of Robert Magara, who testified that on that day, 7th of February, he found Suzan Magara's car abandoned. With the engine running and the lights on. He confirmed that Suzan, his niece, worked directly under him as a cashier at Gwendore Dairy Farm and was missing from the scene. So the fact that the victim Suzan Magara was missing and her vehicle abandoned in the middle of the road with the engine running and lights on proves this ingredient. The made voices saying beat her. Suggests a forced removal. Secondly, the circumstances under which the vehicle was found are wholly inconsistent with voluntary departure of a person from that vehicle and irresistibly point to forcible abduction. The defense did not refute this ingredient in their submissions. I therefore find this ingredient proved beyond reasonable doubt by the prosecution. As to whether the kidnapping was by force and against the will of the victim, the 2 ingredients will be handled together. In the case of Uganda versus Namibia and another, it was stated that offenders often approach their victims using manipulative lures and strategies such as offering gifts, making threats, and using weapons.
wamu n'ebirala okusobola okukwata omuntu okumuwamba.
For this ingredient, there must be proof of the physical taking or removal of the victim from one place to another.
Akantu kano omuntu alina okukakasa nti wali omuntu ono yawambibwa n'aggyibwa mu kifo kimu n'atwalibwa mu kirala.
Against her will or without the victim's consent, by use of force, fraud or coercion.
Era nga teyekkiriza ate nga waaliwo okukozesa amaanyi.
The crime of kidnapping continues until the victim is freed. And a person
okuwamba kugenda mu maaso n'okukolebwa oba n'okuwulizibwa okutuusa nga omuntu oyo awambiddwa asumuluddwa.
And the person who chooses to participate in the victim's confinement after having learned that the victim has been kidnapped may be held responsible for the offense of kidnapping.
Era omuntu oyo agenze mu maaso n'okuwamba omuntu oyo asobola okuba nga avunaanibwa kubanga bw'aba nga yamulina.
The prosecution relied on the evidence of PW1 Muhindo Mugululu Yusuf, who was speaking with the victim via phone at the time of the abduction. And testified to hearing her scream and saying, "Don't beat me." The evidence of Muhindo Yusuf is critical because he was the last independent witness to communicate with the deceased before her disappearance. PW37 Inspector Wandera Desaya confirmed during investigation that PW1 consistently narrated these events and that the information prompted immediate efforts to trace the whereabouts of the deceased.
Omujulizi namba 37 yagamba nti omujulizi asooka yagenda mu maaso nga talinaamu kutankana ng'awaayo obujulizi buno nti omugenzi oyo yamuwulira ng'awoggana ng'akaaba nti temunkuba.
The prosecution also relies on the evidence of PW5 John Magara, who testified that he was instructed by the kidnappers to proceed to Batabata near Jalanjala Kumi to collect a parcel.
Nchera obujulizi bw'omulala omujulizi owokutaano John Magara eyagamba nti yagenda mu kifo kiyitibwa Batabata okuba nga afuna ekitereko ekyo.
As instructed by the kidnappers. And this is corroborated by PW37, who testified that when PW5 and PW6 opened the parcel, they saw severed fingers inside, bearing a red nail polish. And which were immediately recognized by members of the Magara family as belonging to Suzan Magara. A forensic scientist attached to the director of government analytical laboratory. His evidence provides scientific corroboration linking the severed fingers of Suzan Magara, delivered to Magara family, which confirms that she was alive and under the control of the captors during the ransom negotiations. From the prosecution evidence can be conclusively established that Suzan Magara was alive and under the control of the kidnappers at the time the fingers were amputated. Second, the evidence of PW14 established that there was extreme violence meted out on the deceased during captivity. Thirdly, it demonstrated the zeal of the kidnappers to compel payment of ransom through fear and intimidation.
Era kiraga obumalirivu bw'abawambi bagenda mu maaso okubanga basaba ssente ez'obuliwo ennyingi era nga tebatya ate nga bali bakozesa okutiisatiisa.
Fourthly, the parcel directly linked the ransom negotiations to the physical harm inflicted upon the deceased.
Era nti okufuna ssente zino kibanga kiraga nti bakozesa
physical harm.
okubanga bakola obuvune ku mugenzi Suzan Magara.
I find that this agreement has not been contested by the defense, and therefore it has been proved beyond reasonable doubt that
ekintu kino defense oba baloyamwe kyebakyogedeko oba kyebakiganye era nga wa gavumenti bakikakasiza kooti era tewali kabulungu nakamu tebaleseemu.
And therefore it has been proved beyond reasonable doubt that indeed Suzan Magara was kidnapped using force and against her will.
Kikakasiddwa nti bakakasiza kooti ddala kituufu omugenzi Suzan Magara yawambibwa nga teyezimbidde era n'atwalibwa.
We now analyze as to whether the perpetrators of the kidnap were motivated by an intent to procure ransom,
Katugenda nti abo abawamba
for which a person is kidnapped must be gathered from the circumstances attending prior to, at the time of, and subsequent to the commission of the offense.
Omusango guno ogulina okuba nga gukolebwa ng'omuntu ono
The offense of kidnapping is complete as soon as the person is taken away with the requisite guilty intention or knowledge.
nti omusango guno gumala okukolebwa ng'omuntu ono amaze okutwalibwa ng'era abakikoze balina ekigendererwa ekyokuba nga bafuna essente.
And the intention for which a person is kidnapped must be gathered from the circumstances attending prior to, at the time of, and subsequent to the commission of the offense.
Nti era ekigendererwa ky'okuwamba kirina okuba nga kitandikira we batandikidde okumuwamba ne mu kumuwamba n'engeri gye bamuwambyemu ne bwe bamututteko.
PW5 Immaculate Makabe Magara testified that on 8th February at around 2:30 p.m. following the kidnap and barely a day after the kidnap, she received a telephone call from number 0759 249058.
Nti omujulizi namba 5 Immaculate yagamba nti ennaku z'omwezi 8 omwezi ogwokubiri ssaawa nga 8:30 ez'omutuutu yafuna essimu ng'ekubibwa ku ssimu namba 0759 24
9058.
9058.
And during that conversation, the caller informed her that Suzan Magara was in his custody.
Era mu kwogerezeganya n'omuntu eyakuba yamugamba nti omugenzi Suzan Magara yamuyina.
And instructed her to remain calm pending further communication.
Era yamugamba nti abe mukakamu agende mu maaso n'okulinda ekiddirira.
That PW37 further testified that on the 9th of February, the same caller reached out to PW5 and demanded payment of $1 million US dollars.
Era ng'ennaku z'omwezi 9 omujulizi namba 37 yagamba nti ng'ennaku z'omwezi 9 ogwokubiri 2018 nti omuntu y'omu yakuba essimu yagenda n'addamu n'akubira oyo omukyala Immaculate n'amugamba nti baagala $1 million.
As a condition for the release of Suzan Magara.
Era kibali akakwakulizo ak'okubanga omugenzi ateebwa.
The caller further directed that neither security agencies nor the press should be involved.
Era n'amugamba nti tebalina kugattamu bitongole by'abakuumaddembe.
PW37 established that the kidnappers maintained constant communication with members of the Magara family over several days.
Era yagambye omujulizi namba 37 yagamba nti bano abawamba bagenda mu maaso n'okubanga boogeraganya n'abantu b'omugenzi babasaba ssente.
The prosecution further relies on evidence showing that the kidnappers negotiated ransom amounts of $200,000 US dollars.
Era kiraga omujulizi yagenda n'agamba nti abawambe bagenda mu maaso ne balamuziganya n'abafamire y'omugenzi ku ssente ze bali balina okubawa era ne bapakana nga bakomye ku $20,000.
And the kidnappers permitted limited communication with the deceased Suzan Magara.
Era bamala ne bagamba nti
To coerce the family into paying The kidnappers delivered a white box to the family's residence containing 2 severed fingers and a must-watch memory card containing a video clip of the victim. The evidence shows that a ransom was eventually mobilized and delivered as instructed by the kidnappers. PW4 John Magara further testified that the kidnappers designated ransom collection points. The first one being on the 15th of February 2018 on Massacre Road. The second point was on 17th of February 2018 on Bombo Road at Matuga. And at all times, PW4 had the money on him, but all this failed due to kidnappers realizing he was accompanied by security personnel.
Omujulizi owokuna yagamba Kwamisha John Magara yagamba nti ennaku z'omwezi nga 15 ogwokubiri yagezaako okuleeta ssente Masaka Road ng'omali mugambye ne 17 ogwokubiri era ku Bombo ku luguudo lw'Ebombo naye bino byonna byagwa butaka kubanga yali ali amaze okugambako kuba bitongole by'abakuumaddembe.
The last designated collection point was on the 24th of February 2018, at which point PW7 was directed to deliver the ransom to Kanaban Deje.
Awasembayo wewa ennaku z'omwezi nga 24 ogwokubiri 2018 era John Magara yalagibwa nti atwale ssente mu kitundu ky'e Kanaaba Endeje gy'abaziteeka.
PW7 was directed, Flavia Magara was directed to deliver the ransom to Kanaban Deje.
Era omujulizi namba 7 Flavia Magara yalagibwa atwale ssente ezo mu Kanaaba Deje ng'ennaku z'omwezi 24.
She indeed dropped off the ransom money, the $200,000.
Era yatwala ssente ezo emitwalo $200.
PW4, PW5, PW7, and PW37 all confirmed that the kidnappers monitored movements of family members and security personnel, and that's why the first 2 attempts to deliver the ransom money aborted.
Era omujulizi yensonga lwaki okweta ssente ng'ennaku z'omwezi 15 ne 17 ogwokubiri byagwa butaka kubanga ebitongole by'abakuumaddembe byali bibbira kye bimanyiiko.
It is further confirmed by PW4 and PW5 that the kidnappers repeatedly threatened the harm unless payment was made.
Era kigambibwa nti omujulizi namba 4 n'owokutaano bagamba nti abawawaabirwa mwagenda mu maaso n'okutiisatiisa okukola obuvune ku Suzan Magara okusinga ssente ezo ziba teziweereddwayo.
PW37 testified that ransom collection attempts were arranged at Massacre Road and later at Matuga.
Omujulizi namba 37 yagamba nti mwali mwateekawo we mulina okufunira ssente ezo awasooka waali Massacre Road awalala waali Matuga.
That the kidnappers demonstrated prior planning.
Kimwe abaali bawambye mwagenda mu maaso nga mutegeka mukola enteekateeka.
They demonstrated surveillance capability and operational discipline by detecting the presence of security personnel and aborting the collection exercises.
Era mwagenda mu maaso nga mukozesa okwekenneenya n'okulaba we mugenda okufunira ssente obaddala ebitongole ebikuumaddembe tebiriiwo naye mwagenda kukiraba nti nga weebiri ensonga lwaki ennaku zino 2 temwafunamu ssente ezo.
The intent to procure ransom can also be established through the voice audio recordings that were tendered in court through PW37.
Era ekigendererwa ky'okufuna ssente nakyo kyagenda mu maaso ne kitegereze oba ne kikakasibwa mujulizi namba 37 mu butambi obwaleetebwa mu kooti ne bulabibwa.
These were extracted on Exhibit 77, a CD.
Era bino byali ku kapapula 77 era nga kaali katambi.
In one of the recordings, WA00000, the kidnappers indicated to PW4 and PW5 that they did not want the money in installments and should not be counterfeit.
Nchera mwagamba omujulizi owokuna n'okuna nti mwali temwagala ssente za bitundutundu era mwali mwagala ssente za biwundu.
In another recording, WA0045, PW4 informed the kidnappers that he had only United States dollars 200,000.
Era mu katambi akalala omujulizi oyo yagamba nti yalina dola za America 40,000.
These are voice recordings. So in WA000012, the kidnapper directed PW4 to drop off the ransom using a Viz card.
Era mu katambi ako mwalagira omuntu agenda okukola sente azireete ng'akozesa emotoka ye.
The voice recordings are confirmed by PW6 Renata Magara,
Era akatambi kano akogerako kakwatagana n'obujulizi bw'omujulizi ow'omukaaga,
who set them up by downloading an automatic voice record application onto the phones of PW4 and PW5 from the third phone call up to the 19th of February 2018.
Nti era yasalawo okuba nga ateeka okusimu ye akantu akakozesebwa okulikoodinga amaloboozi, era n'agenda mu maaso ng'akateekako okuba nga ennaku z'omwezi okutuusa nga ennaku z'omwezi 12.
PW18 Kanene Enoch, the digital forensic examiner, told the court that in one of the videos, again exhibit number 77, the deceased cried out for help to PW for the father, appealing to him to meet the kidnapper's demands so that she should be released.
Nti era omujulizi namba 18 yagamba kooti nti omujulizi namba 4 mwayitawo omugenzi nti mu katambi ako kakalagibwa omugenzi Ssenemanya yali akaabirira kitaawe ng'amwegayira nti aweeyo ssente ezo asobole okuba ng'ateewa.
PW6 Renato Magara also told the court that she took pictures of the money using PW4's phone after counting it and confirming it was 200 United States dollars.
Nti era omujulizi ow'omukaaga Renato Magara yagamba nti yakuba ebifaananyi essente ezo nga tezinaba kuteebwa oba kuweebwayo gye muli ng'akozesa essimu ye era nga zimaze okubalibwa nti zali.
This was extracted from PW4's phone and can be seen on pages 52, 53, 54, 56, 57 and 58 of the cybercrime report, marked Exhibit 8 by PW18.
Kino kyakakasibwa obujulizi bwa namba obujulizi obwo bwagibwa ku ssimu ey'omujulizi ow'okuna kitaawe Amagara era ne bwetibwa mu kkooti era nga kuli ku mpapula ezo nga bwazolidde.
The evidence regarding the intent to procure ransom is shown by the two attempts at Mpigi and Matuga ransom collection points.
Nti obujulizi obulaga nti mwali mulina ekigendero ky'okutwala ssente nnyingi bulagibwa mu Matuga ne
Mpigi
nga mwali mutaddewo nti okugenda okufulira ssente ezo.
And collection at Kanaba Ndeje. Furthermore, during a scene reconstruction of the crime, PW37 testified that several accused persons, including Ajana Nakandi, A4, and Lubega Yusuf, A1, allegedly described the planning meetings held at Usafi Mosque.
Omujulizi n'abasatu mu musanvu yagenda mu maaso n'agamba nti omuwawaabiro ow'okuna Nakandi Kajera ne Lubega Yusuf asooka nti mwagenda mu maaso ne mukola enteekateeka era nga mwagikolera mu muzikiti gwa Usafi.
A4 Nakandi admitted she was selected to take custody of the victim because they were targeting a female.
Nti Nakandi Hajara yalondebwa okuba nga akuuma omugenzi.
This evidence points to a highly sophisticated operation which was carried out for the sole purpose of obtaining a ransom from the deceased family. And PW9 Wasa Segawa, who witnessed a lady identified as PW7, drop a black laptop bag and phone near Ndeje Mosque.
Nga bulaga nti akasawo oba ensawo omwali ekyebwa ssente ezo yali ensawo twalibwamu akakompyuta katono.
PW9 and his companions saw a man resembling the late musician Mose, later identified as A5, Abubakar Chewolwa.
Musamba agamba nti yalaba omuntu nga afaanagana omugenzi omuyimbi Boze ng'ajja.
Pick up the bag after the lady left.
Nti era najja n'atwala ensawo nga immaculate amaze okuvaawo.
PW9 identified Abubakar Chewolwa both in the parade and in the dock.
Nti era omujulizi ow'omwenda yasobola okutegeera Abubakar Chewolwa nga yemuwawalibwa.
At the parade and at the dock. These eyewitness observations of the physical act of delivering and collecting the ransom money demonstrate that the group was actively engaged in receiving the proceeds of their crime. The most harrowing evidence of intent came on the 19th of February 2018, when PW4 received a parcel at Haas petrol station containing 2 silver fingers of his daughter and a memory card marked as a must-see video inside. PW12 later recovered this parcel from the family. Recovered this parcel from the family. While PW18 Kanene Enoch extracted the video from the SD card showing Suzan Magara in visible distress, pleading with her parents to pay the ransom so she could be released. And she had a bandage on her injured left hand. PW36 Juliet Naiga transcribed and translated the recordings, capturing Yakubu's instructions on the amputation of the fingers and their delivery to their father as leverage.
Omujulizi namba 36 yagenda mu maaso n'aleeta akatambi nga kalaga Yakubu ng'alagira okuba nga basalako omugenzi bali Magara ebala nga bazireeta okuba nga baziwa kitaawe.
The defense attempted to explain the land and vehicle purchases as legitimate business transactions.
Banyonyola nti okugula emmotoka zino byali bya bizinesi.
They claimed that the accused had independent sources of income.
Bagamba nti mumali mulina sente zammwe oba mwali mulina bizinesi ezibawa sente.
That some properties were family related and that purchases were made through normal commercial channels.
Ebintu ebimu byali bya family ate ebirala mwabigula nga muyise mu
However, I find these explanations were general. They were vague and largely unsupported by specific documentation or credible alternative funding sources. And they did not adequately address the highly suspicious timing immediately following the ransom demands and collection. Why in March, after the February kidnap and the murder on 25th and 27th? Immediately after the murder, then transactions of buying, a spree of buying property ensued. Crucially, the defense failed to produce any records, accounts of independent witnesses to show legitimate pre-existing funds sufficient for these substantial purchases.
ensibuko y'essente ezo ze mwakozesa nga mugula ebintu bino.
For instance, Yusuf Lubega could not substantiate as to how he said he had about 3 or 4 vehicles.
Okugeza Yusuf Lubega tasobola kugamba kooti kukakasa kooti engeri ki gye yafunamu emmotoka nyazi yalina.
Yet he only claimed he was compensated by UNRWA with the 18 million.
Ate nga wagamba kooti nti waweebwa ssente okuva mu UNRWA 10 million 18 eza Uganda.
And so I find this agreement is proved beyond reasonable doubt.
N'olwekyo asanze nti awa gavumenti bakakasizza akantu kano kabaka waayiro kano nga tebaleseewo obulungu.
That the explicit ransom demands, the fiscal collection at Ndeje by A5, the video and transcripts of coercion and amputation instructions, and crucially, the subsequent coordinated purchase of 35 acres in Buike and other land in Luero, vehicles with large cash sums by the accused person and the associates forms an irresistible inference of specific intent to procure and enjoy ransom money.
Okubanga ssente zino zaafunibwa n'okubanga ebintu bino byagulibwa n'okubanga zaafunibwa okuva Ndeje zaafunibwa mu Kanaaba n'okubanga ebintu bino byagenda mu maaso ne bigulibwa mu mwezi ogwokusatu bino byonna kitegeeza nti ssente zino zaabikola zaali zino ezaafunibwa oluvannyuma lw'okutta omugenzi Suzan Magara.
So I find that the prosecution proved beyond reasonable doubt that the intent of the kidnap was to secure ransom.
Era asanze nti abagavumenti bakakasizza kooti nti ekigendererwa ky'okuwamba omugenzi Suzan Magara kyali kya kufuna ssente zino nnyingi ezaafunibwa.
I shall deal with the aspect of participation later.
Kyagenda kukwata ku kintu eky'okwenyigira mu
I shall now deal with the offense of murder.
oluvannyuma ne kagende ku musango gw'okutta.
The elements of murder that require proof beyond reasonable doubt are that there is death of the victim,
Omuntu okakasa nti omuntu yazizza omusango gw'okutta ekisooka alina okukakasa nti waliwo omuntu eyafa.
that the death was caused unlawfully,
Nti omuntu ono yafa nga atiddwamu
the death was carried out with malice aforethought,
nti era waaliwo ekigendererwa ekyokutta omuntu ono.
the accused persons participating in the commission of the
Era
offense
abantu abamu
for the death,
era be bavunaanibwa omuntu ono.
death of the victim.
Okutta omuntu.
The death of the victim was established through the recovery and formal identification of the body,
Nti okutta omugenzi Suzan Magara kwabaawo oluvannyuma olw'okuzuula obulamu bwe.
The body was found dumped at Kitiko Birongo along the Entebbe Express Highway.
Nti era omulambo gwe gwasangibwa nga gwasuulibwa mu kifo ekiyitibwa Kitiko Birongo.
The victim's father, PW for John Magara,
Kitaawe w'omugenzi Suzan Magara
and Aunt Flora Magara
ne Flora Magara
testified the effect that they identified the body of Suzan Magara at the scene.
nti era baawa obujulizi nti baakakaza nti kuno omulambo gwa mugenzi Suzan Magara.
It was later formally identified at City Mortuary by her uncle Robert Magara,
Nti era oluvannyuma gwategeera anko we oba kojjaawe
at City Mortuary. At City Mortuary, where they were now undergoing a post-mortem process. The post-mortem report of Suzan Magara was tendered by PW3 Dr. Moses Jaruhanga, a pathologist.
Nti era okwekebejja omulambo guno kwaweebwayo mu kkooti obujulizi obwokusatu Dr. Jaruhanga.
It documented the physical state of the body, including missing fingers.
Era yalaga omulambo guno gwali gutya n'alaga nti n'engalo zaali zivuddeko.
And the cause of death was put as asphyxia.
Nti era ekyaleeta omuntu okuttibwa omugenzi okufa,
which means lack of oxygen.
Kyerina okuba nga yasibibwa ku mmundu ku mwayi ne ku nnyindo ng'alikiddwako nga tasobola kussa.
And the post-mortem report proving this fact was tendered in and marked as Exhibit PE5. Second ingredient that the death was caused unlawfully. But the legal position of the legality of death, or lack thereof, is that every homicide is presumed to be unlawful unless circumstances make it excusable.
Kyagambibwa nti okutta kwonna kwonna kutwalibwa nga si kutuufu okujjako nga kukakasibwa ekintu ekirala nti oba kwali kutuufu.
This position was laid down in the case of R versus Gusambiza, son of Wesonga. The same position was restated in a call Patrick and others versus Uganda, 2006 HCB. The way it was held that in homicide cases, death is always presumed unlawfully caused unless it was accidentally caused in circumstances which make it excusable.
Kyayogerwa nti mu misango gyonna egy'okutta nti kitwalibwa nti omuntu yenna yattibwa mu bumenyi bw'amateeka okuggyako nga kikakasiddwa nti oba waliwo ekigerebwa ekyokuba ng'omuntu oyo afa.
The prosecution relied on evidence of PW13 who conducted a post-mortem on the victim.
Nti gavumenti beesigama ku bujulizi bw'omujulizi namba 13 eyawaayo oba yakebejja omulambo gw'omugenzi.
The body was delivered to them on 27th of February. And they described the body as being that of a female adult with a height of 158 centimeters. 158. It was a well-nourished body. She had been putting on a short-sleeved, collarless black t-shirt. She was also putting on a black body tight, trousers, black socks on a blue net knicker. She was stained with brown feces and also had a purple bra. Particles and leaves on the outer cloth. Fingernails and toenails were painted red and maroon respectively. Rigor mortis had set in already. Rigor mortis is a state of kind of shock. If a person dies, you find the person rigid in the way he died. That means that by the time they saw the body, she had been dead for at least more than 12 hours. There was blood-stained floors on the nose and mouth. There were 2 pinpoint healing abrasions below the right knee and some insect bite injuries on the right elbow. And the cause of death was described as asphyxia. So I find that this ingredient was also proved beyond reasonable doubt. The third ingredient was that the death. For a court to infer that an accused was killed with malice aforethought, it must consider if death was a natural consequence of the act that caused the death, and if the accused foresaw death as a natural consequence of the act. Section 174 of the Penal Code Act provides as follows on malice aforethought, that malice aforethought may be established by evidence providing either of the following circumstances. One, an intention to cause the death of any person. 2, with the knowledge that that act or omission causing death will probably cause the death of some person.
nti era nga waliwo okutegeera oba n'okukakasibwa nti omuntu eyakoze ekintu ekyo yakikoze ng'era agamba nti omuntu alina okufa nti oba n'omulala ayinza okufa.
Although such an act is accompanied by indifference whether death is caused or not mining.
ekintu ekyo kikolebwa kiba kiraga nti oba omuntu ajja kufa oba tajja kufa.
So, to establish malice aforethought under Section 191 of the Penal Code Act, the prosecution is not required to provide direct proof of the accused's state of mind, as courts recognize the inherent difficulty of proving the mental state of a person at the time of commission of an offense.
Okubanga omuntu akakasa nti omuntu yalina ekigendererwa ekyokutta omuntu mu kawaayiro 191 ak'ekitabo ky'amateeka, aba gavumenti balina kugenda mu maaso n'okukakasa ddala kituufu omuntu oyo alina ekigendererwa ekyokutta omuntu, wabula balina okuba nga beetooloolera ku ngeri ky'omuntu oyo gye yafaamu.
Instead, the law relies on circumstantial evidence to infer intent, guided by the principles laid out in R versus Tubere.
Nti naye amateeka geetooloolera ku bujulizi obukwatibwako obuba buweereddwa nga bwe byayogebwa mu musango ogwo ogwogeddwako.
In that case, the court gave the following guidelines of circumstances from which an inference of malicious intent can be deduced.
Musango ogwo kkooti yawa ebintu ebyo ensonga omuntu atta omuntu ng'alina ekigendererwa alina kuba alogebwako atya oba omutegeera ku ki.
We look at the weapon used,
ekisooka otunuulira ekintu
whether it was a lethal weapon or not.
Obanga ekintu ekyo kyali ekintu ekikozeseddwa okutemu kyali kibi.
We also look at the part of the body that was targeted,
n'otunuulira ekitundu ky'omubiri gw'omuntu eyafudde,
whether it's a vulnerable part or not.
Obanga ekitundu ekyo ky'omubiri kya.
And we look at the manner in which the weapon was used.
N'otunuulira engeri ekintu ekyo ekyakozeseddwa okutta omuntu gye kyakozeseddwamu,
whether repeatedly or not,
oba kyakozeseddwa emirundi n'emirundi oba
or the number of injuries inflicted.
oba obuvune obwateereddwa ku muntu eyafudde.
And we also look at the conduct of the accused before, during and after the incident.
Era n'otunuulira enneeyisa y'omuntu eyakoze ekikolwa ekyo nga tannaba kutta muntu n'okumutta omuntu n'oluvannyuma ng'amaze okutta omuntu oyo.
In Uganda versus Uwera, the court had occasion to hold as follows. A number of factors are considered when establishing malice aforethought in homicide cases. Because the perpetrators of crimes rarely use their voices to voice out their intention when committing the offenses. Malice aforethought is therefore a state of mind. And that the courts usually deduce or make inference of the intention or knowledge from the circumstances surrounding the killing of and the weapon used, the mode of the killing, the nature of the injuries inflicted. And the part of the body affected. And then the conduct of the accused. I will not explain the nature of weapon, the part of the body, the conduct of the accused before and after the commission of the offense because it's straightforward. But there must be premeditation. The evidence reveals clear premeditation in this case. The group planned the abduction of Atusafi Mosque. They assigned themselves roles as testified by PW 10 and PW 37. They procured lines and ketamine. They held Suzan for nearly 3 weeks. They amputated her fingers when the ransom was delayed. And ultimately killed her when she became a liability, for she had been held for too long. The communication matrix as testified by PW18 and PW43 and reconstructions show coordinated, deliberate actions over time, not a sudden, impulsive act. Malice aforethought. Their claims of torture and custom and alibis have no bearing on the circumstances of Suzan's death, and no evidence suggested the killing was accidental or lacked intent. The deliberate ossification, the prior amputation of the fingers, the prolonged premeditated detention and torture, the subsequent concealment and profiteering from the crime, collectively demonstrate both express and implied malice. This ingredient is firmly established in the case of Katoka Jubi, Uganda versus Katoka Jubi. That malice aforethought can be inferred from the nature of the injuries, the part of the body targeted, and the surrounding circumstances. Furthermore, ossification is a progressive, highly physical process that requires sustained, uninterrupted effort over several minutes to transition from unconsciousness to death. Furthermore, ossification is a progressive, highly physical process that requires sustained, uninterrupted effort over several minutes to transition from unconsciousness to death. This duration would have provided the perpetrator with a temporal window to desist, but since they persisted, the persistence required to ensure death through these means completely eliminates the possibility of an accident. Instead, it confirms a resolute, calculated effort where the perpetrators acted with specific intent to kill, or at a minimum with absolute knowledge that their conduct would inevitably cause death. Mwabawanga omugenzi Suzan Magara mwagenda mu maaso n'okuba nga mulina ekigendererwa eky'okumutereka ate oluvannyuma ne muleetera okufa. So I find this ingredient of malice aforethought proved beyond reasonable doubt. Kyekitegeeza asanze nti kino ekintu ekyekigendererwa ekyokuwamba n'okutta nga kiki. Now we deal with participation of the victim. Ekirala kirina okukakasibwa kkooti nti ddala kituufu nga bababalira bamanyumira. There should be credible and direct or circumstantial evidence implicating the accused persons as perpetrators of the offense. Under Section 19 of the Penal Code Act, individual criminal responsibility can be incurred by being a direct perpetrator.
Nti akawaayiro 19 ak'ekitabo ky'amateeka kalaga nti omuntu kinnoomu asobola okuba nga agambibwa nti yenyigira
or a joint perpetrator
obanga kyakolebwa wamu. kumi na mwenda ak'ekitabo ky'amateeka kagamba nti abantu bayinza okuba nga bali wamu
or joint perpetrators
bali wamu oba ali omu oba balina banne ababenyigidde
acting under a common concerted plan.
Era nga mwenna mukolera wamu nga mulina ekigendererwa kyekimu.
They can be accessories before the offense
oba muyinza okuba nga mukwataganira wamu
by aiding or abetting,
era nga mugezaako okuba nga mwagala okuzza omusango
etc. So the evidence implicating the accused must show that the factum of kidnapping as well as intent to procure ransom and murder were known to them directly or at least by circumstantial evidence.
Obujulizi obubanga bubaleetera okugamba nti mumazza omusango guno bulina okuba nga buboogerako era nga bulaga ddala kituufu mu mwakola omusango ogwo.
The prosecution relies substantially on circumstantial evidence
Nti abagavumenti beesigamye ku bujulizi obw'enkukunala
against the accused persons.
obulaga nti ddala mwe mwaza omusango guno.
It is the nature of evidence of surrounding circumstances which by undersigned coincidences is capable of proving a proposition with the accuracy of mathematics.
Nti obujulizi buno obulaga nti ddala kiri ku mwaza omusango guno obujulizi bwetolera ku ngeri ki omusango guno gye gwazzibwamu era ne wawe gwazzibwa n'engeri gye gwazzibwamu.
The law holds that it is no derogation of evidence to say that it is circumstantial.
Amateeka gagamba nti obujulizi tebulina kuba nti tekigaana nti obujulizi kugamba nti obujulizi bwa nkukunala.
Rather, it does not reduce the weight of the evidence. It remains evidence.
Tebusala ku buzito bw'obujulizi naye obujulizi obusigala nga.
However, each and every incriminating circumstance must be clearly established by reliable evidence.
Naye buli ekigendererwa oba ebyetoolera ku bujulizi obwo birina okuba nga birabibwa nga obujulizi.
And the circumstances proved must form a chain of events from which the only irresistible conclusion about the guilt of the accused can be safely drawn. Such that it remains as the guilt of the accused. The court must find before deciding upon a conviction that the exculpatory facts are incompatible with the innocence of the accused and incapable of explanation upon any other reasonable hypothesis than that of guilt. It is thus essential to inquire with the other hypotheses there may be, which may agree wholly or partially with the facts of evidence. Though the prosecution is relying on circumstantial evidence, it must be woven together with a series of strands, which includes the communication matrix, crime scene reconstructions, evidence, photographs showing vehicles, boats. In other words, accumulation of wealth after the alleged crime. It is also woven together with the alleged call data records. The prosecution relied on testimony of PW10 Frank Nyakairu, who testified about the early investigative response to the kidnapping and to the eventual identification of the perpetrators. He told court that he is the one who initiated tracing measures on the telephone numbers used by the deceased. He testified that the following lines belong to Magara, Suzan Magara, that is 0774 634 696. And another line 070 163 4696. The two lines belong to Suzan Magara. The evidence of PW10 was obtained before suspects had been identified and therefore carries substantial evidential weight because it represents the initial investigative findings. That witness also testified that they formed a multi-agency task force for investigating this offense, and using some numbers which were identified belonging to Biensi, Yakubu Biensi, and Lugolobi. He prepared a communication matrix using a machine called Y2K, which then showed Yakubu Biensi's associates. Yakubu was in constant communication with the number 0702 318 422 of Yusuf Lubega.
Nesimu namba 0702
and a number of 0758 478 810 belonging to Hakim Golobi. The witness further told the court that the matrix he prepared indicated all the accused persons, namely Yusuf Lubega, were in constant communication before, during, and after the kidnapping of late Suzan Magara. The witness prepared a technical report and a communication matrix, which was admitted in court, marked as Exhibit 1. The PW10 also told court that the team arrested Yusuf Lubega's mother and brother, and the mother and brother admitted that the number which we had mentioned earlier on top belonged to Yusuf Lubega. PW10 told court that there were two numbers which were marked in two different locations. And indeed, when he checked using his mobile money application, that number attributed to Lubega Yusuf actually belonged to Lubega Yusuf. And after mapping them, they matched with the clusters, that is 0702318422, and the cluster of Hakim Lugolobi, the cluster of Lubega Yusuf, and the cluster of Lugolobi Hakim.
Yagenda okusanga nti nga ennamba eno n'endala gye twayogedde zonna zaali ziri mu mpuliziganya Lubega Yusuf wamu ne Hakim Lugolobi.
Even the one of Hakim Lugolobi, he checked using his mobile money application. It revealed it was for Abdul Hakim Lugolobi. The prosecution relied on evidence of Kanene Enoch, PW18, a forensic expert, analyst. He analyzed the telecommunications made during the kidnapping and ransom period. In his cybercrime report, he established that 0758478810 in the same location in Masaja Zana. Zana. When an unknown number, anonymous caller, in the names of Owino James, called PW5. But that was on the 19th of February 2018. And that this is the very anonymous number which was in communication with another number, 0757 0757 008 906, which was in Isma Bukanya's name at Namasuba. At Namasuba. That on the same date of 19th of February 2018, Hakim Lugolobi, using the same number, communicated to 075951 07595 100 4747, registered in the names of Mahad Kisalita. The number which was also linked to the anonymous number of Owino. But in his analysis, the numbers, the ones attributed to Yusuf Lubega's name, and 0704715578 belong to Yakubu BNC. And the number 0705284468 of Hassan Kato. And then another one, 0724444634 of Abbas Musa. And then of 0782739003 of Bukenya Isma. And another of 0705780720 of Hussein Waswa. Were all found to be common associates of number belonging to Hakim Lugolobi. Forensic report. Exhibit number 8. PW 18 further established in his report that Yusuf Lubega's number was used in Matuga at the same time when the unanimous number ending with 481 communicated to PW for John Magara. In Matuga on the 17th of February 2018. And that this very number happened to be an associate of Lugolobi Hakim, who was also in Matuga at the same location. The prosecution also relied on the evidence of PW 21 Inspector Chichot Robert, who was attached to Director of Forensic Services in Naguru, and was central in documenting the various crime scenes connected to the kidnapping and murder of Suzan Magara. His testimony was professional, it was objective and supported by photographs, with sketch plans, with the scene reports and video recordings, all of which were admitted into evidence. It was in this evidence that on 27th of February, he was dispatched together with other forensic officers with PW 37, the lead investigator, to Kitiko Birongo village off the Kajansi Munyonyo Express Highway, following information that the body of a female believed to be Suzan Magara had been recovered.
Express Highway.
It was his evidence that he prepared a sketch plan, he photographed the scene and compiled a scene report, which was admitted as Exhibit 10, Exhibit 11, and Exhibit 12 respectively. PW 21 also stated that he participated in several scene reconstructions and conducted with the different accused persons. That on 14th of May 2018, A1 and A5, Nakandi and Abubakar Cholowa, voluntarily led investigators to a parcel of land in the Buike district. And during the reconstruction, the accused explained that the land measuring approximately 35 acres had been purchased using part of the ransom money obtained from the family of the deceased. And that he recorded that the entire reconstruction exercise on video. The accused persons identified building materials, and explained that the intended developments were to be financed using the ransom proceeds.
Era mwamugamba nti ebintu bye mwali mugenda okukola ku ttaka eryo mwali mugenda bikola nga mukozesa ssente zaali zisigaddewo okwezi mwali mufunye ebbungi.
On 15th May, he participated in another reconstruction exercise in Luero.
Era mu 15 omwezi ogwokutaano yagenda mu maaso n'okugenda ewalala
involving Lubega Yusuf, Aid Bukenya Ismail, and other accused persons.
kuliko Lubega Yusufu ne Bukenya Ismail wamu n'abalala.
They were led to that other person in Luero, parcel of land in Luero,
Mwamutwala mu ttaka eddala ery'e Luweero.
where they said they had purchased it at about 14 million.
Era mwamugamba nti mwaligula miliyoni 14.
They saw there a small house incomplete, which was under construction, a pit latrine under construction,
Nti yasangako ennyumba entono eyali ekyagenda mu maaso n'okuzimbibwa wamu ne kaabuyonjo.
cassava gardens, fencing poles, and building materials.
Nti wamu n'ennimiro ya muwogo wamu n'ebiti ebyali bikozesebwa okusibako.
And that Yusuf Lubega explained that the house was intended for caretakers, while the land would be used for agricultural purposes.
Nti era mwamugamba nti Yusufu Lubega yamugamba nti ennyumba yali ya muntu akuma ettaka eryo nti wabula ettaka lyo yali yakozesa kulimirako.
PW121 further testified regarding the reconstruction conducted with A4 Hajara Nakandi and A5 at Natete and Upper Kunge.
Nti era yagenda mu maaso n'okuwa obujulizi okuba mu ngeri gye mwamutwalako gwe Nakandi Hajara wamu ne Kyolwa Abubeka mu nnyumba y'ekkonge omumulaga bwe mwali mutereka.
It was his testimony that the accused persons voluntarily led investigators to the house in Church Zone, Natete, where Suzan Magara had initially been detained.
Era bwali bujulizi nti nga mweyagalidde mwamutwala mu nnyumba esangibwa e Natete gye mwali mukuumiddemu omugenzi Suzan Magara.
That during the reconstruction, A4 demonstrated how she cared for the deceased, escorted her to the bathroom, and confirmed that Suzan Magara was blindfolded and her mouth sealed with adhesive tape throughout her captivity.
Nti era wamugamba bwe Nakandi Hajara wamugamba engeri gye mwali mukumamu
There before being transferred to Upper Nkonge.
nti era mwamukuumira eyo nga temunnaba kumugyayo kumutwala mu Upper
He also testified on the reconstruction of Nkonge house, at Upper Nkonge house.
Nti era yagenda mu maaso nawe obujulizi engeri gye mwamutwala mu nnyumba ya Upper Nkonge.
And F4 identified the bedroom in which Suzan Magara had been confined after being transferred from Natete.
Nakandi Hajara n'omulaga ekisenge mwe mwali mulabikira Suzan Magara.
And she explained that she had been led there by Yusuf, by Yakub, while blindfolded.
Nti era ne mumugamba nti watwalibwayo omuntu gwe bayita Yakubu.
And remained there under continuous guard.
Ng'osibiddwako ku maaso nti era n'obeera eyo ng'okuuma Suzan Magara.
Both F4 and F5 identified the roles played by various members of the group.
Nti bwe Nakandi Hajara ne Kyolwa Abubeka mwagenda mu maaso ne mubuulira obujulizi ono alimu omu
including the guarding of the deceased by A7,
nti n'okugenda mu maaso okumugamba nti
Kato Hassan,
okukuuma omugenzi wakukolanga wamu ne Kato Hassan.
the delivery of the ransom money to Nkonge house by A5,
nti n'okufuna essente
Bubakar Charua,
okuzireeta mu Nkonge house.
the cutting off of the deceased's fingers and her subsequent murder by A9,
nti era okusalako omugenzi engalo kwakolebwa omuvumba Musa Abbas.
PW21 documented these reconstructions through photographs and video recordings,
Nti era bino byonna yabikola ng'akozesa ebifaananyi wamu n'obutambi.
thereby preserving the accused person's demonstration of the various crime scenes and their respective roles.
Era yagenda mu maaso n'okuba nga alaga engeri gye
PW21 also testified that he documented the reconstruction of the ransom collection at Lubugumu, Nindeje,
nti era yagenda mu maaso n'agamba nti yawaayo engeri gye
was positioned He identified where PW7 placed the ransom bag and the point where they bypassed each other. He explained how he eventually picked up the money before transporting it to Conge House, and also confirmed the presence of bystanders at the point of pickup and the ransom. And this was corroborated by PW9, who is now one of the witnesses who identified A5 at the scene of crime. This reconstruction materially corroborated the prosecution evidence concerning the collection and subsequent distribution of the ransom proceeds. PW21's evidence is of much value because it provides objective forensic documentation of the crime scenes, and independently corroborates the prosecution's narrative of the offenses. His testimony links all the accused persons to the places of detention, the murder scene, the collection and disposal of the body, as one piece of evidence. Significantly, the accused persons themselves led investigators to locations that were previously unknown to the police and demonstrated their respective roles during the commission of the offenses. PW21's evidence corroborates the evidence of other investigating officers and other prosecution witnesses. But above all, it places the kidnappers, all the accused persons, at the center of kidnapping, detention, ransom collection, and eventual murder of Suzan Magara. This evidence is further corroborated with the testimony of PW22, ASP Muhangi Adam, who was a police officer attached to the Director of Forensic Services, and who by then was the head of the Forensic Photography Laboratory. He too said he participated in the crime reconstruction exercise with the PW30 ASP Pius Chaningom and AIP Yanusu Baise. So, as seen above, this evidence is corroborated, evidence of PW21 is corroborated by evidence of other police officers. PW22 stated that on the 30th of April, he was with Afande Chanigom Pius and Baise Yunus at the police headquarters, where they were briefed by the Kampala Metropolitan Commander, then Olal Johnson, and later by Grace Akulo. That they were briefed about the exercise. And after briefing them, the two suspects,
nga bamaze okuba
A1 Lubaga Yusuf and A8 Bukenya Ismail, were taken to them by Desire Wandera.
nti nga bamaze okubabuulira bye bagenda okukola abawawabirwa asooka Lubega Yusufu wamu ne Bukenya Ismail.
They went and inspected the various crime scenes.
Batwalibwa gye bali omu gwe bayisa Wandera era ne batwalibwa mu bifo eby'enjawulo ebisango gye bwazibwa.
So they went and inspected the various crime scenes, starting with the Usafi Mosque. And they documented their findings. They were led to another place in Makin and Makai zone, where they had first attempted to kidnap Suzan Magara, but they aborted. Then they led them to voluntarily led them to Lunguja, to a tarmac stretch, which led to Suzan Magara's home, where they kidnapped her from using a motor vehicle, Karina UAK, where they kidnapped her using a Karina. And when you look at the videos, this is confirmed in the video exhibit number 54 that was played in court, where A1 is seen explaining the type of vehicle that they used, and later confirmed by A8. The above evidence is corroborated by PW33 Lule Moses, who told his honorable court that on 2nd of May 2018, A1 led him to Isaac's garage located in Naulu Kolongo, and upon reaching the premises, A1 identified motor vehicle registration number UAK 140U.
Nchera obujulizi buno bukwatagana n'obujulizi obwa omujulizi namba 33 yagamba nti ng'ennaku z'omwezi 2 omwezi ogwokutaano 2018 nti omujulizi omuwaliro asooka Lubega Yusufu yamutwala mu kifo eky'Nalukolongo yasanga emmotoka namba UAK
140U
1040U,
and he took photographs of the same vehicle. After the scene of kidnap, the two suspects, A1 and A8, told the team that they knew where Suzan Magara was first confined. And they were willing to take them to that place, Natete Child Zone. But around 1100 hours, A1 and A8 took the team to Church Zone Natete, where the place was identified as A4 Ajara Nakani's home. They observed, took pictures, and recorded that the house was in a perimeter wall and had two entrances. That after the Natete Church Zone, the team was led to Kasenge, Nakiraba Zone, then Bulenga on Michana Road. The following day, 1st of May, after the team was briefed by AIGP Akulo, who was the director of CID then, the kidnappers had placed phones and for their that A1 and A8 led the team to Kajansi Maya, where A1 informed the team that the accused persons had placed phones at a certain point and directed PW4 to go and pick them up to enable him to communicate with them, the accused persons.
owokuna mwali mutadde amasimu awo ekasenge nti era mwamugamba agende agagyeyo agatwale nti musobole okuba nga mubeera nga mwogerezeganya wamu naye.
From there, they were also led to a place on Masaka Road at Ocean Energy Petrol Station, where they had again put some phone. The area was observed, it was swampy with papyrus plants on both sides. And that's where they placed the phones, near some signposts, as was seen in the exhibit number 54. That after that they went to Matuga along Kampala Road, Kampala Guluru Highway, past the Matuga police station, on a downward slope, and A1 showed the team the exact point where the ransom was meant to have been dropped. Again, it was not successful because PW4 went to security. They also taken to another ransom pick point along Entebbe Road. PW22 stated that A1 told them that the ransom was $200,000, which was equivalent to about 700 million, and this is corroborated by PW4, PW5, PW6, and PW7. PW22 documented and recorded all the above seals that were tendered in court as Exhibit 18. The reports and 19 sketch plans. He then imaged the recordings on the 32 GB flash disk. And that Exhibit 54 was played in court, showing all the places described above. So PW22's testimony provided an independent forensic corroboration of PW21's evidence.
Omujulizi namba 22 yagenda mu maaso obujulizi bw'okwatagana obujulizi bwa mujulizi namba.
And PW22 maintained that during cross-examination that he personally observed no injuries during reconstruction, no suspect complained of torture, and A1 Lubega freely volunteered information during reconstruction of crime scenes. This evidence directly rebuts the defense of allegations that the reconstruction was obtained through coercion. PW22 further explained that the report was prepared jointly with PW38 ASP Channing, who was then the team leader. PW40's evidence directly follows and corroborates the evidence of PW38, Pius Ranigom, who had earlier testified that after completion of the reconstruction exercises, he received the custody of the flash disk, which is Exhibit 54, from
era obujulizi bwa
from Muhangi Adam PW 22.
bw'omujulizi namba 40 bukwatagana obujulizi namba 38 abagamba nti bwe baamala bafuna obutambi obwo ne babuteeka ku kamputa bayita flash disk then ne babutegeka bulungi ne busobola okuweebwayo mu court.
And this is seen to serve this serves to confirm that the chain linking the evidence is authentic and it was done with integrity.
Kino kitegeeza nti obujulizi bwabwe babunoonyereza bulungi era baakozesa obukugu n'obwegendereza nga babunoonyereza era nga babufuna era tewali nakantu nakamu kamenyebwamu nga banoonyereza obujulizi.
It showed the integrity of the electronic exhibits evidence.
Obwegendereza n'obumanyirivu nga bawaayo akatambi ka kooti.
PW 37 further told court that the accused person revealed at interview and since contact that out of the ransom money they bought 9 vehicles and land.
Omujulizi namba 37 yagamba kooti nti omwage bwe yagenda mu maaso n'okuwabuuza mwamugamba nti mu ssente ze mwaweebwa mwagula ettaka wamu n'emmotoka.
And this confirms the prosecution's narrative that the kidnapping was committed for financial gain and that the ransom money was subsequently disputed among the participants for a common purpose of acquisition of properties to benefit the Muslim widows and orphans.
Kitegeeza nti ekigendererwa ky'okuwamba n'okutereka n'okutta kyali kigendererwa kya kufuna ssente nnyingi okuba nga mwegaggawaza n'okuba nga mugenda mu maaso n'okugaggawaza.
This is corroborated by the fact that they procured commercial vehicles and a big chunk of land near Lake Victoria for commercial agriculture.
Kino kiraga nti obujulizi n'obukwatagana n'obujulizi obulaga nti mwagula amamotoka ne mugula n'ettaka ddene kumpi n'ennyanja Nalubaale.
To strengthen this assertion, the prosecution relied on the evidence of PW25 Luganda Geoffrey, who told court that he sold his land in Buba village, Sisa Buikwe district on 3rd of April 2018. And he said that 11 people went to his home in Kimbeja, Nalia, but only 4 entered his house. That is Hakim Lugolobi, Lubraga Yusuf, Waso Hussein, and someone called Sadiq. It was this evidence that he was able to identify them A1 and A2, and at the time of the transaction, using the security light outside his house. So, it is prosecution's submission, which this court agrees with, that after receiving the ransom, the accused persons began acquiring assets.
Kitegeeza nti bwe mwamala okufuna ssente ezo mwagenda mu maaso n'okufuna ebyobugagga.
The transactions form part of the evidence showing how proceeds of crime were converted into assets.
Engeri gye mwafunamu ssente ne muzigyamu ebyobugagga.
The significance is not merely that the land was purchased, but that several persons acted jointly in the acquisition process.
Tekitegeeza nti ettaka lyagulwa naye kitegeeza nti ebintu bingi byagulibwa mu ssente ezo.
And therefore they acted in concert and with a common intention.
Tekitegeeza nti mwakwataganira wamu era mwali mulina ekigendererwa kyekimu.
It also confirms conduct after the offense.
Era kiraga n'amasimu agaagulibwa oluvannyuma lw'okuzibwa omusango gwazibwa.
The same was from the land obtained from Luero.
Era ebimu mu ssente ezaagulibwa.
Irene Namubiru, the owner of the land, testified that the land, she sold her land to the accused persons.
Namubiru Irene nannyini ettaka yagamba nti yatunda ettaka yaliguza mmwe.
So she said that he saw in that land Salimu Zamiru, Bukenya Ismail at the chairman's place, and they all proceeded to the vendor's place, who was called Irene Namubiru.
Nti ku ttaka eryo yalabako Bukenya Ismail wamu ne bano nga mugenza wa chairman.
That the prospect purchasers returned to inspect the land Later on, possibly identified as Lubega Yusuf, Salimu Zamiru, Bukenya Ismail. Yes.
nti abaali bagamba okugula ettaka omwaka omwawo ku ttaka eryo era nga yemmwe Lubega Yusufu, Salimu Zamiru wamu ne Bukenya Ismail.
In each of the instances, the land sale agreements were made
Nti era mu bino byonna
and signed.
endagaano zaakolebwa era ne ziteekebwako emikono.
There was also evidence from people who sold motor vehicles.
Era waliwo n'obujulizi ku bantu ababaguza emmotoka ez'enjawulo.
For instance, Mutebi Kigula, who was a businessman dealing in used motor vehicles at Ndeba.
Nga Mutebi Kigula eyali akola okutunda emmotoka enkadde mu Ndeba.
His evidence links A8 Ismail Bukenya to the purchase of a motor vehicle shortly after the kidnapping of Suzan Magara. He sold the UAV 138G Isuzu Elf to him. It was evident that the buyer was Ismail Bukenya. The agreed price was 25 million. And there was a written sale agreement. Imamul, PW30, also testified. To the various sale of land of a motor vehicle, Rosa bus, which he first sold to John Mugamba, and later on Hadija bought it. PW35 Mugamba John testified that he sold motor vehicle registration number UBB 711R, a Fuso Rosa bus, to A4 Jarana Kandi for approximately 80 million. $80 million. PW35 identified in court the document that confirmed the 10 million had been paid and the vehicle was to be transferred in Air Force name. PW32 identified receipts issued in relation to the transactions, documents containing his handwriting, his signatures, and a photocopy of driving permit associated with the transaction. PW32 directly identifies Lubega Yusuf and connects him to the substantial motor vehicle transaction. Together with the PW25 to PW29, 30, 31, his evidence helps establish a pattern of land and vehicle acquisitions that are consistent with the enjoyment and distribution of ransom proceeds following the kidnapping of Suzan Magara. He also recovered, PW37 also recovered documents pertaining to the properties acquired, as the logbook was recovered from A8, UAP 232F Toyota Hiace, white in color, UAX 962G Toyota, also white and blue. The agreement between Mbabazi and A8 and the logbooks were recovered from A8. For UAK 140U, Karana using the kidnap was also recovered. Then UBB, a boon was also recovered. Air Force vehicle used in transporting the body was found hidden in Mukono.
Obujuzi bwa namba 357 bwalaga nti okutawa w'emmotoka bwagezaako okukyusibwa ng'era bino byonna byali bikolebwa mu mateeka bamanya gwa Kenya Ismail omuwala omutaka munaana era n'abalala abaafuuka mmotoka nga mulimu n'ababaka. Era ne bagamba nti endala emmotoka emu yasangibwa ng'ekwekeddwa omukono.
So it should be noted that logbooks, photographs and titles were all exhibited in court. And their numbers established. Other persons' evidence which is of value were from witness number 15 onwards. 15, we also had the PW20, Musumba Dennis, who did the arrests of the accused persons. Yes. On conduct, it was submitted that the conduct of the above accused persons was not consistent with, was not that of innocent people. And this was elaborated earlier on, because Chewala Bubakar obstructed the team who was trying to arrest Bukenya, and Yusuf Lubega ran into the mosque, and which caused the chaos. Prosecution witness number 43 testified the telephone number 0702 318 422 belonging to Yusuf Lubega was perhaps the most significant number analyzed. Using Airtel Know Your Customer records, he established that Lubega's telephone number was registered in names of Lubega Yusuf. Using his driving permit. The subscriber details included Lubega Yusuf's date of birth, the driving permit, Kajansi Old Park records, and SIM registration details. So this independently connected A1 to the telephone number used throughout the conspiracy. PW3 analyzed months of call records and found a communication pattern. Instead of isolated calls, he demonstrated continuous communication between A1 and specific telephone numbers
Nkyera yasanga nti omuwaabi bw'asooka Lubega Yusufu yali alina ennamba ez'enjawulo
For instance, that one belonging to Mahad Kisalita.
Nti okugeza eyo eya Mahad Kisalita.
PW43 testified that this telephone number of Lubega Yusuf
yagamba nti esimu eno ya Lubega Yusufu
and number 0757008966 belonged to A8 Bukenya Ismail.
Nti n'eyo ennamba endala gy'ayogedde yali ya Bukenya Ismail nga era mu muwaabi w'omunaana.
And he established that the two numbers, that of Bukenya and the one of Yusuf,
era yasanga nti ennamba bbiri eya Bukenya n'eya Yusufu
repeatedly communicated with one another on the following days. On the 8th, on the 9th, on the 19th, on the 22nd, on the 24th, on the 26th, and 27th of February. That the communication was both incoming and outgoing. That the persistence of these contacts before and during the kidnapping period strongly suggests operational coordination rather than casual communication. PW43 further analyzed another Airtel number ending with 481, which was anonymous. This number communicated with a number ending with 186 that belonged to PW5, Immaculate Magara. When she was at Gombe Matuga. Immaculate Magara. Immaculate Magara. When she was at Gombe Matuga. This is highly significant because PW4 had testified that the kidnappers directed the ransom money to be delivered at Matuga. This shows the connection between Matuga ransom instructions, phone activity at Matuga, independent telecoms, confirmation, and all at the same time. So that Airtel record therefore corroborates PW4's evidence regarding the ransom collection point at Matuga. Now let me go now to analyze the evidence of each and every one of you and what court attributes it to. It should be noted that you, the accused persons, put up defenses of total alibi, total denial, alibi, and torture. I'll start with Lubega Yusuf. He denied participating in the kidnap of murder of Suzan Magara. While he admitted that he was taken by security operatives for reconstructions, he stated that he was tortured while at CMI detention. But he claimed he was acting under duress and coached on what to say to save his life. He also downplayed his association with the co-accused, claiming he only went to whatever mosque was closest to him and had no knowledge of the criminal syndicate or the Usafi Market mosque meeting. However, his defense directly contradicts the forensic evidence of PW22, Superintendent of Police Muhangi Adam.
Obujulizi bw'okukontana n'obujulizi obwa police officer number 22 ey'obujulizi Muhangi Adam
and PW21 Inspector of Police Chot Robert, who established that he freely navigated and pointed out locations, including the Buike land and the exact spot Suzan Magara was abducted from. He also led the reconstruction team to a place in the Kitoko Birongo where they dumped the body of Suzan Magara.
Wagenda mu maaso n'okutwala abapoliisi officers bano gye mwaziza emisango nga togabiddwa kino nakiri n'obatwala bulungi mu bifu byonna byonna naye nomala n'obatwala gye mwasuula omulambo gw'omugenzi Suzan Magara ebirongo.
Though he attempted to explain his income via wound recompensation, his denial collapses under the weight of a telecommunication and eyewitness evidence, which places him as the driver of the getaway vehicle.
Era newandibadde wagamba nti bwe wali olina engeri gy'ofunamu ssente z'oba walina bizinesi naye ebyo byonna wabyogera naye nga obujulizi obwawebwa bulaga nti wali muntu avuga taxi.
According to PW10, A1 was traced through his phone ending with 422, which number was confirmed by his mother and brother. And this led to his tracing and eventual arrest at Usafi Market.
Nti enamba ensembyayo 422 yanoonyerezebwako wa police officer era ne bakukwatira mu muzikiti gwa Usafi ate ne maamawo ne baganda bano ne bakkiriza tewali.
I must say defense witness one at Yusuf Lubega proved a very useful later as he volunteered all the information which even led to the arrest of the other accused persons.
Nti Yusuf Lubega nti wawa obujulizi buno oba watwala abapoliisi officer bano yonna gye mwaziza omusango nga topakkiddwa nti era n'obagulira ne banno abazza omusango nga bwe mwabuza era ne bagenda mu maaso nawe okubakwata.
He admitted kidnapping of Suzan Magara and her eventual death and dumping of her body at Kitiko Birongo.
Era wagenda mu maaso okukkiriza nti mwawamba Suzan Magara era ne kugamba nti
It should be recalled that it was on the 9th of February 2018 when Magara John was called by the ransom seekers. It was on the 9th of February 2018 when Magara John was called by the ransom seekers. Those the defense brings out confessions and which they say they retracted. Some of the accused persons tried to say that they were tortured. But they fell short of proving the torture allegations. And therefore the confessions which came out of the accused persons voluntarily were seen and repeated during the scenes of crime to the full glare of court. In actual fact, there is a glaring evidence of overt acts with common intention, a shared purpose, and actual participation by all the accused persons. This can be seen even through The roles played by each of the accused persons as narrated by Yusuf Lubega and Nakandi by and large.
Kino kirabibwa olw'okuba nti omunnammwe Yusufu Lubega ne Nakandi bagenda mu maaso nga boogera ku buli omu mwenna wano we muli ki buli omu kye yakolanga okuwamba n'okufuna ssente n'okutta okugenza.
The role of Yusuf Lubega was surveillance. He drove the car, the Karina.
Lubega Yusufu kwali kwekenneenya era n'okuvuga motoka Karina,
which was used for the kidnap.
eyakozesebwa mu kuwamba mugenzi.
He was involved in taking the body for dumping, among others.
Wenyigira mu kutwala omulambo gw'omugenzi Suzan Magara okukasuka ne mwakukasuka.
A2 Wasa Hussein and A5 Bubukar Chalwa were together with Hassan Kato to keep guard of Suzan Magara for all the 21 days, along with Nakandi Hajara.
N'owokutaano wamu n'owomusanvu mwali mwenyigira mu kutereka okukuuma n'okutereka obuwambibwa era byonna gye yali mu nyumba.
Buvumba Musa Abbas was the one who cut off the fingers of Suzan Magara.
Buvumba Musa Abbas yegwe wasala engalo z'omugenzi Suzan Magara.
And he was the one to treat the wounds as well.
Era yegwe olebye okujjanjaba ebivundi.
He also injected the deceased with a ketamine drug.
Era yegwe wakuba omugenzi empiso eyamujja mu bulamu bw'ensi.
Ismail Bukenya A8, Mahad Kisarita A6, Salim Muzamiru
Bukenya Ismail
A3,
Kato Hassan Miro Salita Mahadi ne Salim Muzamiru.
I don't know what I said. Okay, did I say that one? I said Ismail. According to PW10, Yusuf Lubega volunteered most of the information with which most of the accused persons were arrested.
Okusinziira ku bujulizi bw'omujulizi ow'okumi yagamba yawaayo obujulizi bwonna engeri omukumu awo omuli engeri gye mwakwatibwa.
He gave them the numbers of others.
Nti yabawa ennamba z'abalala.
Not to forget to mention that the pictures of the money in dollars were taken and shown in court.
Nti era tumwerabira nti ebifaananyi bya dollars ze mwafuna byakubibwa era ne bireetebwa mu kkooti.
A1 also revealed that they laid in wait for Suzan Magara at a road near her home in Lunguja.
Nti omugwali wasooka Lubega Yusufu wagamba nti mwekweka ne mulinda omugenzi Suzan Magara kumpi n'ewuwe e'Lunguja.
He revealed that it was him and Musa Abbas and Abubakar Chawolwa and Kato Hassan who kidnapped Suzan Magara.
Wagamba nti yegwe Lubega Yusufu ne Waswa Hussein ne Kato Hassan abawamba omugenzi Suzan Magara.
He revealed that it was Musa Abbas, Abubakar Chalwa and Kato Hassan
wagamba nti yegwe yali Chewolwa Abubakar ne Musa Abbas ne abenyigira mu kwamba omugenzi Suzan Magara.
Who went and dragged Suzan Magara from her car as he waited in the car. He revealed the preparation that was done by them for this kidnap, that in the preparation for the mission, they bought toy pistols and a hammer for breaking the windows in case she refused to open the car. That he revealed that Musa Buembo removed her phone and he warned her not to make noise or scream. Now we go to Wasa Hussein D2, DW2. Denied being part of the criminal enterprise regarding the Usafi Mosque raid. Stating that he was present nearly for prayers and saw no pangas or weapons among the worshippers. He alleged that the police and army officers were the actual aggressors who assaulted them. He also raised claims of severe torture, detailing that he reported He's ordered to Buganda Road Court and was subsequently examined by Lusera prison doctors. And doctors from ACTV. He argued that the prosecution evidence is riddled with contradictions regarding where he was arrested. He denied being an adult by the time of the commission of the offense and his arrest, but should be said and noted that his denials fell flat. Was alibi and claims of innocence are overshadowed by Detective PW 37 Wandera Desire. PW 21 and PW 10, who placed him at the core conspirational meetings where the ransom scheme was hatched. The torture claims were rebutted by the overwhelming forensic telecommunications matrix and the physical identification evidence during reconstructions of the scene evidence. Which revealed his role as that one of guarding and monitoring. A2 and A7's lies about their age were not helped either by the testimony of defense witness number 12 and defense witness number 13, as they contradicted each other and were declared liars by court. The near official court witness number 1, Brenda Kesabu Agaba, affirmed their date of birth as 25th of January 1996, as per the information declared by A7 at NIRA. That revelation placed them to be over 18 years of age by the time of the commission of these offenses. We go to Sali Muzamiru. He consistently raised preliminary objections and defense outbursts regarding his treatment. He pointed to earlier human rights enforcement applications and orders. It was also his evidence that doctors had examined him for torture injuries from CMI. And that he had never received justice or a formal ruling on the matter. Through his unsworn statement and defense counsel, he maintained that he knew nothing of the kidnap. He had no connection to Suzan Magara and only signed all other statements due to coercion. So like A2, Salih's defense attempts to invalidate the entire prosecution case by pointing to procedural irregularities and human rights violations during pre-trial detention. However, the court found this to be tactical ploys to delay proceedings. Given that his DNA profile, call logs, and participation in the joint enterprise were scientifically tied to the crime scenes.
nga kiraga nti ebyempuliziganya z'amasimu go byali bikutwala bulungi nnyo emisango webazza emisango omwaka guno nti nga muwabira abawaga gavumenti.
But this too was dismissed for having gone against the wrong party.
Era nagwo gwagobebwa kubanga mwawabira abantu bakyamu.
All in all, the torture allegations were not substantiated. And yet the prosecution has gone in length to prove the offenses of kidnap, to procure ransom, and murder of the deceased by the accused persons beyond reasonable doubt. Having found as above, the recent decision of the Court of Appeal, sitting as the Constitutional Court in the case of Farouk Mohammed and others, versus Attorney General and others, Constitutional Petition number 17 of 24, and Constitutional Reference number 2 of 2024,
nti nga tugenda mu maaso n'okufunira omusango guno ogwa Farouk Mohammed ogwasalibwawo kkooti ensukkulumu.
The Court of Appeal was dealing with an issue which arose on the validity of Article 11(2)(a)(c), permitting acquittal without trial where non-derogable rights are violated.
Gwagenda mu maaso okwogera ku kawaayiro 11 a cha ne a akalaga nti omuntu basitaba nga eddembe yatulugunyiziddwa eddembe lirimugibwako asobola okuba nga agenda mu maaso n'okwedderezebwa omusango.
And the Court of Appeal held that an accused person in Uganda who has been subjected to torture is entitled to the exclusion of any evidence obtained through such unlawful means. But where the remaining administrative evidence is insufficient to sustain a conviction, the accused may properly be acquitted. However, this exclusionary rule does not extinguish the accused's guilt. The accused remains answerable for the offenses committed.
Era kkooti yagenda mu maaso n'egamba nti omuntu yenna kasita asangibwa nga yatulugunyizibwa era obujulizi bwonna bwafunibwa wakati mu kumutulugunya n'okuba nga bakozesa okutiisatiisa, omuntu oyo asobola okuba nga yedderezebwa omusango. Naye kino tekitegeeza nti omusango omuntu gw'aba yazza guba guggibbwawo, ate ekirala nti omusango guba gulina okuwulibwa naye n'ogenda mu maaso kuba.
This court then held, the Constitutional Court then held that Section 112A, 11(2)(a), B and C of the Act is unconstitutional insofar as the said provisions allow for the acquittal of an accused person based on the finding of a violation of non-derogable rights without a fair hearing and trial in respect of the initial offences brought in the criminal proceedings.
Koti yagenda mu maaso n'eyogera bw'etyo nga bw'akisomye.
Maybe try to help her. Help her. Okay, let me explain it. Let me explain it this way so you can put it simply. The court, therefore, the Court of Appeal recently is just very, very recently, I think a month ago, it declared that Section 11(2)(a), B, C, and C of the Act unconstitutional.
Yagamba nti akawaayiro 11(2) A ne C nti tekali mu mateeka.
Because the said provisions allow for the acquittal of an accused person based merely on a finding of a violation of a non-derogable right without a fair hearing and a trial in respect of the initial offences brought in the criminal proceedings.
Kubanga akatundu kano kalaga nti omuntu yenna asangibwa nga atulugunyiziddwa alina okuba nga ayejjerezebwa omusango ate nga tagenze mu maaso nakuba nga agenda mu maaso omusango okuwulirwa okubanga okulaba ddala oba yaguze oba teyaguze.
So now it means it does not entitle you. That Enforcement Act has been rendered unconstitutional just because you're saying you were tortured, then you want to be acquitted. No, that's what the court has said. You'll still be held responsible for offenses which you are charged with. that you are committed, and they have to prove those offenses against you. I have therefore this to say, that therefore even the allegations of torture, given the present circumstances, would not exonerate them from the offenses of intention to procure ransom and murder of Suzan Magara. So Buvumbo's defense is a total denial coupled with complaints regarding trial management.
Wagenda mu maaso obujulizi bwe waleeta obw'okwegaana wagenda mu maaso nga ogenda mu maaso okuwulirizibwa.
However, the prosecution placed him directly in the physical abduction team alongside Abubakar Shorowala and Buvumbo Musa Abbas and Kato. See video evidence of the scene of reconstruction, which corroborated his presence in the vehicle. And this directly refutes his claim of complete ignorance of the crime. He brought a witness, the first witness of his sister, and that between the 3rd and 10th of February 2018, they were in Kiboga for a family get-together for 1 week and 2 days.
Waleta omujulizi nga sistawo ng'agamba nti wali toliiwo nti era wakati w'ennaku z'omwezi 3 ne 10 omwezi ogwokubiri nti mwali Kiboga mu lukiiko lwa famire kino kyali kitegeeza nti wali toliiwo ng'omusango guno guzibwa.
So the first witness 9 and the first witness 18 contradicted each other. Both the sister, the mother, and Buvumbo contradicted each other. Leaving court to ask who was lying in the circumstances. 2 people said they were in Kiboga. 1 said they were in Mitiana. So exactly where was he during that time? We see this as a major contradiction which goes to the root of the matter. And I'll refer to the case of Serapio Tinkasimire, where it was held that it's not every inconsistency that will result in a witness testimony being rejected. It is only grave inconsistencies unless satisfactorily explained, which will usually, but not necessarily, result in the evidence of a witness being rejected. And that minor inconsistencies will not usually have the effect unless the court thinks they point to deliberate untruthfulness.
Okukontana mu bujulizi okw'amaanyi kuyinza okwetera omusango oba obujulizi okuba nga bukkirizibwa oba nga bugalana naye okukontana okutali kw'amaanyi tekusobola kuleetera bujulizi okuba nga bugalana.
I've also analyzed the evidence of other witnesses of the defense. Up to your 20th witness. As I said earlier, I will not belabor at this point to say them. Suffice it to say, at least, and analyze the analysis of court on your defenses, and compare to the evidence of the prosecution. So in this instant case, the prosecution destroyed the defense of alibi of A2 and A7 through the evidence of PW10, PW21, and PW37.
mu bujulizi abajulizi oba gavumenti baleeta abajulizi wano owa 10 abaleeta obujulizi obwali bujjawo okwegaana omwali bulezi.
A2 and A7 were squarely placed at the scene of crime through the testimonies of the above mentioned witnesses.
Mu bujulizi buno bwe baleeta abo omwalirwa owokubiri Waswa Hussein n'owomusanvu Kato Miro kwalaga nti mwali mwenyigira mu kuwamba n'okufa.
It is quite low, as already noted above, that the defense of an alibi must be raised at the earliest opportunity.
Amateeka bagamba nti obujulizi oba okwewozaako okugamba nti tewaliwo ng'omusango guzzibwa kulina okuba nga kwogerwako nga omusango gukyagenda mu maaso nga kutandika butandisa okugenda mu maaso.
The defense of alibi in this case is incredible because it was raised belatedly, among others.
Okwewozaako okugamba nti temwaliwo kwaletebwa ng'omusango gulinamu okukubwa ekitegeeza nti kwali tekulina makulu.
And the defense of alibi raised by the accused persons was destroyed by the testimonies of PW21, who interviewed A1 Lubega Yusuf, A4 Nakandi Hajara, A5 Chawala Bubakar, and A8 Bukanya Ismail on camera, and they admitted participation in the murder and kidnapping of Suzan Magara.
Obujulizi obw'okwewakana oba okwewozaako okwewakana kwagibwawo obujulizi obw'omujulizi 21 eyagamba nti omwalirwa asooka n'owokuna n'owokutaano n'owomunaana bonna baali nga balayira mu katambi nti beenyigira okuwamba
Common intention.
Kati ngenze mu kigendererwa ekyawamu.
It was the submission of the prosecution that under the doctrine of common intention, all the accused persons are liable for the offences they were charged with jointly and severally.
Abagavumenti bagamba nti ekigendererwa ekyawamu nti mwenna mwali muvunaanibwa kubanga mwalina ekigendererwa ekyawamu ekyokuwamba n'okufuna ssente wamu n'okutya.
The doctrine of common intention is provided for under Section 20 of the Penal Code Act, which deals with joint offenders in prosecution of a common purpose.
Ekigendererwa ekyawamu kisangibwa mu kawaayiro 20 ak'ekitabo ky'amateeka ekitabo ekituga amateeka ag'emisango egya Nnaggoola era nga kigamba nti mwenna wamu mulina okuba nga mulina ekigendererwa.
It states that when two or more persons form a common intention to prosecute an unlawful purpose in conjunction with one another, and in the prosecution of that purpose, an offense is committed of such a nature that the commission was a probable consequence of prosecution of that purpose, each of them is deemed to have committed the offense.
Kitabo kigamba nti abantu bonna bwe basangibwa nga balina ekigendererwa ekyokukola omusango era ne bagenda mu maaso ne bateesa ne bakola ekigendererwa ekyo ne bakituukiriza ne bakola omusango, kitegeezebwa nti mwenna wamu muba mutwalibwa nti mumazza omusango.
Common intention can be inferred from the presence of the accused persons, their actions, and the omission of any of them to dissociate from the assault.
Ekigendererwa ekyawamu kiragibwa
From the offense.
neeyisa wamu byammwe ne mu bikolwa by'okugeza ng'okwegaana omusango wamu n'endala.
The common intention to commit extortion and kidnapping is established through the testimony of Detective PW37 Wandare Desire.
Ekigendererwa ekyawamu kiragibwa mu bujulizi obwa Wandare Desire nga ye mujulizi wa
He detailed that the meetings were held at Usafi Mosque where the accused persons, including Lubega Yusuf and others, agreed to identify wealthy individuals to kidnap for ransom in order to fund their group's operations.
Yagamba nti meeting wamwafuna olukungaana mu buzikiti bwa Usafi nga muli wamu ne Lubega Yusuf era mu meeting eyo mwagamba nti mwakkaanya wamu nga mukkaanya okuba nga mugenda okuwamba n'okuzza obugagga.
Common intention can be drawn from the conduct and surrounding circumstances of the parties.
Era ekigendererwa ekyawamu kiba kifunika okuva mu neeyisa yammwe nga mumulisiza omusango n'engeri gye mwaguzaamu.
The captivity, the extortion, and murder phases reflect the ongoing operation of common intention.
Okuwamba n'okutta wamu n'okufuna ssente byonna biraga nti mwalina ekigendererwa ekyawamu.
Evidence from forensic walkthroughs and the testimony of PW37 confirm that Suzan was held at the residence of F.O. Nakandi Hajara.
Obujulizi obw'omujulizi namba 37 bulaga n'obujulizi obulala obwayitibwa abalala ba police officers n'obwava mu bitongole bya polisi bulaga nti omugenzi Suzan Magara yawambibwa era n'aterekebwa mu nnyumba y'omuwaabi owokuna Nakandi Hajara.
While A.Ed Bukenyi Ismail took physical custody of the $200,000.
Ate omuwaabirwa ow'omunaana Bukenya Ismail yafuna essente ezo
and laundered it through forex bureaus to Nakandi.
Ezaawamu emitwalo 2 era
With Nakandi.
Okusiwanyisa mu bibanda bya ssente eby'enjawulo omuli Nakandi.
When the negotiations seemed to have stalled, the group escalated their action by collectively deciding to sever her fee.
Mwagenda mu maaso kubanga muteeseganya wamu ne famire y'omugenzi mwagala ssente ze mwagala mwagenda mu maaso n'okugitiisatiisa nga musalako engalo z'omugenzi Suzan Magara.
And ultimately, when holding her became a security risk, they resolved to murder her and dump her body at Kitukubirongo.
Era oluvannyuma bwe mwalaba nti okumufuna wadde mwali mumaze okufuna ssente mwalaba nti okumutereka kyali kibaleetako kyali kikosa eddembe lyammwe oba n'obulamu bwammwe mwagenda mu maaso ne mumutta nemukasuka.
See video reconstruction evidence which corroborated this aspect. And that multiple accused persons assisted in transporting and dumping her remains. So where a group pursues an unlawful purpose and murder becomes a probable consequence of that enterprise, every member involved in the joint venture is equally guilty of the resulting murder. The continuous uninterrupted cooperation from the Usafi Mosque meetings up to the disposal of the body establishes common intention beyond reasonable doubt. All the prosecuting witnesses were subject to intense cross-examination, and none of the evidence was discredited, but all pointed to the guilt of the accused persons, and that the evidence led by the prosecution proves all the ingredients of murder against the accused person. Kidnapping and murder.
Mwenyigira mu kuwamba n'okutta omugenzi Suzan Magara era tewali kubuusabuusa.
Whereas it may be argued that the prosecution evidence is circumstantial, it has been held and is straight law that circumstantial evidence is the best evidence.
Newandibadde nga obujulizi bw'aba gavumenti obwaleetebwa nti bulaga nti mwakola ebikolwa ebyokuwamba n'okutta omugenzi nti naye obujulizi obwekukunala obulabibwako obujulizi obukolebwanga obujulizi obukulu.
When the evidence of PW1 to PW37 is considered as a whole, the following facts emerge clearly.
Nti mu bujulizi obwaweebwayo abajulizi okuva ku asooka mpaka ku 37 butwalibwanga obujulizi obulambirira naye bino byalabikiramu.
Suzan Magara was abducted on the 7th of February 2018. Her captors immediately began demanding for ransom. The communication evidence tracked the communication networks used by the kidnappers. Family members assembled the ransom and attempted delivery. Independent civilian witnesses observed the participants during the ransom collection. Suzan Magara remained alive and during captivity. Her fingers were amputated and delivered to her family. Forensic evidence confirmed that the fingers belonged to her. The ransom was eventually collected. A deliberate decision was made to kill her. She died from asphyxia. Her body was disposed of at Kitiko Birongo. And investigations linked the accused persons through communications, recoveries, reconstruction evidence, and witness testimony. It is therefore my finding that the evidence submitted by the prosecution forms one complete and unbroken chain, pointing irresistibly to the guilt of the accused persons and excluding any reasonable hypothesis consistent with innocence. Accordingly, in agreement with the opinion of the assessors, I find that the prosecution has proved the case beyond reasonable doubt. And each of the accused persons, namely A1 Lubega Yusuf, A2 Wasa Hussein, A3 Salim Samiru, A4 Nakandi Hajara, A5 Abubakar Sholowa, A6 Kisalita Mahad, A7 Kato Hassan Miro, A8 Bukanya Ismail, and A9 Buvuma Musa Abbas are convicted as charged for the offense of kidnapping to procure ransom control section 243(1)(c) of the Penal Code Act and murder control section 188 and 189 of the Penal Code Act.
N'okutta omugenzi Suzan Magara.